When it comes to regulations, I think we all know the Egypt competition law was amended with effect from 30 December 2022. The amendments introduce a mandatory pre-notification regime in Egypt, different to the post-notification regime that applied up until now. Executive regulations still need to be published and put into place regarding the concept of control and the determination of thresholds. And a key debate, and maybe we'll hear Willard on that later, is around whether or not a filing to COMESA will necessarily exclude that to Egypt as well going forward. There's much uncertainty attached to that. The COMESA continues to be one of the most active regulators. It is currently reviewing the regulations which were promulgated in 2004 to bring them up to date. Those will deal with many, many concepts, including questions of control, whether or not the regulations have exclusive jurisdiction, and, I mean, significantly introducing a suspensory regime. At the moment, COMESA is a non-suspensory regime, but the plan is to introduce one which aligns with the practice all over the world. Proposed changes to the law in Eswatini, Malawi, Namibia, and Zimbabwe are envisaged, with the old law being repealed and being replaced. A draft competition bill is currently going through the stages of assent in Uganda, which will then introduce for the first time competition law in Uganda. The plans are afoot to operationalize the Burundi, Comores, and DRC competition authorities. As regards enhanced cooperation between regulators, during this year, the COMESA Competition Commission embarked on several initiatives to enhance cooperation between regulators, in particular in Burundi, Comores, and the DRC, as I've mentioned, as well as the Ethiopian Ministry of Trade and the Malawi Commission. The COMESA Competition also revised its MOUs inter alia with the Kenyan Competition Authority, as well as entering into a MOU with the Eurasian Economic Commission. Finally, when we met last, I mentioned that the competition law landscape has changed dramatically, and this flux continues to be the case. I mentioned that tests for competition law outcomes that were accepted as gospel a few years ago are now being turned on their heads, with a focus on preserving structural competition and with regulators becoming more interventionist. This has been evident internationally, where regulators have focused on information and data and the market economic and societal power that creates, even where there's no obvious or immediately apparent harm to consumer welfare. In South Africa, the Commission has been particularly active, and I think many of us here have been involved in the online retail market inquiry. While the Commission has been somewhat blunt in its approach at times, it should on balance be commended for its efforts in wanting to address the imperatives and challenges arising in South Africa, in particular insofar as addressing inequality, the racially skewed nature of our economy, and facilitating the participation of small business and Black-owned businesses in the economy. That said, and I must apologize, I'm going to be a bit critical now, the Commission should be criticized for its opaque and unpredictable approach to merger assessment and to certain merger investigations, in many cases being a key factor undermining investment. Despite the amendments to the public interest provisions of the Competition Act some almost 4 years ago, the Commission has not yet issued any public document or guidelines regarding the manner in which it will approach the consideration of those provisions. The Commission's approach is very different to the commendable approach of other regulators in Africa. And the impression of business is that there's a lack of appreciation of the unintended consequences of its approach. It appears, with respect, I sound like somebody else, that the Commission is merely looking for a case to send to the tribunal instead of grappling openly and frankly about the challenges of giving meaning to the new provisions of the Act, and accepting the responsibility of the balancing act that comes with doing so. The Commission is well positioned to mitigate the uncertainty by offering proactive guidance and should not be waiting for the tribunal to do so in a test case. It's in that context, and I must just express my sympathies to the chair of the tribunal, who tragically had a family bereavement recently and who can't be here today, but also then to express my sympathies to her family. but also then to welcome and ask Professor Liberty Ngube to make the opening remarks. Professor Ngube is a member of the Competition Tribunal and a professor of economics at the School of Economics and Finance at the University of Witwatersrand. I actually am aware about another appointment, but I can't say anything about it just yet, as much as I'm tempted to do so. Professor Ngube is a member of the President Ramaphosa's Presidential Economic Advisory Council. He served as a member of Minister Patel's Ministry Advisory Panel tasked with developing draft amendments to the Competition Act, which ultimately culminated in the amendments we saw in 2018. Professor Ngube was also a chief economist at the Competition Commission, serving as chief economist from January 2014 to February 2019. He is an expert in the application of economics to competition law, and he has provided expert economic testimony in merger control, abuse of dominance, and cartel cases, both for the Commission and for respondents. He holds a PhD in economics from the University of KwaZulu-Natal and an MSc in economics from the University of York. He teaches, supervises, and writes on competition economics, industrial organization, and competition policy, and his scholarship is published in local and international journals. It's with that, I'd like to welcome Professor Ngube and ask him to say the opening address.
So I count myself very lucky. As an enforcer, I sat opposite teams of lawyers at, Bowmans being one of them. As a practitioner, I sat alongside Bowmans as their expert in a few matters. Now, as an adjudicator, I sit and listen to Bowmans hire other experts, present their cases, and wonder what has happened. But a lot changes when you sit at the tribunal. So it's a pleasure and an honor to join you today. I think the number and the quality of attendees is testimony to the importance of the issues you're going to discuss today. Chairperson Mondo Mazwai would have loved to be here and with you. And as Derek has said, there's a personal bereavement and for that reason, she's not been able to attend. I will share with her my experience with you today. In 2019, the amendments were effected to the Competition Act with the aim of transforming markets to become competitive and inclusive. Of late, what we've seen in the tribunal is a reinvigorated interest in exclusionary conduct and in public interest issues, as the scope of interpreting these through the lens of participation and also transformation develops. Many of you would have observed that the decisions of the tribunal in merger control, particularly on public interest and on competition matters, focus on providing competitive prices, making sure that there is greater participation, and also promoting a greater spread of ownership, together with fostering economic growth in terms of productivity. This is in line with our statutory mandate. Our statutory mandate stands in many ways very distinct and different from elsewhere around the world. I read an article in December, I think, in the Wall Street Journal, where the current chairperson of the FTC, Lina Khan, was speaking about the US, and she was commenting about ESG. And then she went on to say, I think the title of the article is ESG Won't Stop the FTC. In that article, she argues, convincingly for a US audience, that their job is to prevent illegal measures and not to make a world a better place. This, of course, is different from South Africa. Our job in merger control is to make South Africa and Africa a better place, one case at a time, in line with our statutory mandate and with a focus on both competition and public interest. So those of you who are keen observers of the work of the tribunal may have noticed that the workload has increased as a result of the amendments, that there's been an increase in complexity, and that complexity arises from a number of perspectives. And I'm just going to take a moment to reflect on two. First, if you take major control, the expanded considerations around mergers on competition and public interest issues has increased the ambit in terms of our considerations of major control. And what that has done is to make the hearings much more longer. In prohibited practices, there's been an energized interest in exclusionary conduct as we try to to think through how participation works itself out in an exclusionary act. This is different from the jurisprudence that had been developed prior, where one was focusing on whether there is entry that's prevented or entry or an exit. So this the entire architecture around exclusionary conduct is up in the air, and we've seen this in interim relief applications. Court judgments also continue to influence the tribunal's operations. The Constitutional Court's emphasis of competition authorities' obligation to interpret the act in a manner which upholds the values of the Bill of Rights in the Constitution in Mediclinic means that we will continue to apply a transformative, constitutional, and context-sensitive approach to the determinations in order to address the inequalities that are present in our economy. We expect that the intersection between competition and constitutional law will continue adding more to the workflow of the tribunal and to the complexity of the issues that we have to think about. Recently, in an interim relief application, where issues of participation were key. In fact, the three interim relief applications last year all had interesting takes on what participation is. But in e-media, the CAC evolved the jurisprudence to include a constitutional transformative view on interim relief applications. So Mediclinic continues to influence how we interpret the law. Interestingly, the tribunal itself is almost 24 years old this year. It was established to be an independent, impartial, adjudicative body whose function is to hear and decide mergers and prohibited practices. From its creation, the tribunal essentially had two features. One, a specialized expertise from a legal standpoint, and an economic standpoint. And then the second was a more expedited process. In terms of expertise, the tribunal, as all of you would know, is composed of lawyers and economists with varied and extensive industry knowledge and professional experience. The premium placed in the tribunal in terms of specialized knowledge and experience is high. Competition law is really different. Its identity depends on economics. Competition cases require the ability to hear and understand economic evidence and argument. This applies to tribunal members as it does to tribunal staff who assist and manage casework. In Mediclinic, the Constitutional Court specifically emphasizes that the CAC must assess the tribunal's decision in a merger by taking into account the composition of the tribunal and the expertise of the tribunal. The point is that the ever complex issues before the tribunal require an ever more careful scrutiny. Greater sophistication of evidence and analysis also requires depth and familiarity with the issues. Recently, you'd have seen the announcement by the tribunal of the addition to the tribunal of 3 preeminent senior counsel. I think this is a positive development for the system. In terms of process, the tribunal has developed rules and practice directives that make its proceedings efficient, and expeditious so that it can handle cases more effectively and more rapidly. The tribunal has generally performed well in major cases in terms of them being set down and decided within statutory timelines. It is sometimes said, mainly I have to say by those who should know better, some of you here in the audience, that the tribunal takes too long in writing its decisions. I have a different view for two reasons. First, this is not universally true. Second, where it has happened, there are reasons for it. So these reasons largely relate to internal considerations. For instance, the COVID-19 pandemic. Many of you would have known, because the tribunal did say at the time, that it was prioritizing COVID-19 cases, the excessive pricing cases, in order to contribute to sustaining trust in markets and confidence in markets, and by protecting consumers from, at the time, unjustifiable high prices. The tribunal also said at the time that it was prioritizing measures. And for these areas which were prioritized, many decisions were issued timelessly. The effects-based system at the core of many of our competition assessments has become more sophisticated, driven, as I've said, by new concepts such as participation in the market. And I've seen a few economist groups here, the economists with more and better data and some strange analytical techniques. In contested cases, many of the tribunal decisions have become much more longer, reinforced by the need to have ample economic evidence to go with them. Perhaps this is an issue of trust, a trust in terms of the community. When the tribunal knows and expects that there's going to be an appeal, you expect that the decision is going to be longer because it has to anticipate any possible challenge. That's a trust issue. In cartel behavior, for instance, that has become more complex and more devious, sometimes requiring some thoughts on characterization. The economics of abuse itself has become even more complex. Consequently, getting opposed cases to the point of decision is taking longer, and writing short reasons has become more difficult for the reasons I've said. So while we recognize that the turnaround times can be improved, the tribunal has taken steps to improve the time periods of issuing its decisions. These steps include strengthening case management and getting on board additional tribunal members. In terms of expert evidence, it is an important trend or procedure that has developed in recent years has been to have panels of experts as witnesses. This is sometimes called the hot tabbing of experts. Having experts appear together and asking questions to one another is helpful in narrowing down the issues and helps in opposite to an adversarial process where an expert is trying to defend the position of the party that has hired them. I anticipate that that practice is going to continue. In case management, in most cases, the tribunal has been pretty hands-on in setting down case management conferences to fix timetables in order to have the hearing take place. The tribunal has, in some cases, imposed on parties limits on how long the hearing is going to run. This is sometimes called a chess clock process. In this process, the tribunal inquires from counsel representing opposing parties how much time they need for the oral hearing. Counsel will tell the tribunal, for example, we need 2 weeks or 3 weeks, and then the tribunal decides and allocates time accordingly. Say, let's say 35 hours for one team or 35 hours. So each team goes into a hearing knowing exactly how much time it has. This process has been very helpful in narrowing down issues and focusing the case on what is really at the core. and also helpful in getting counsel to get to the main issues in a timely manner. So there's no time, if you realize that the cross-examination is not going anywhere, there's no need to continue with it because you're running down your clock. So the chess clock process as a mechanism has been very effective in helping the tribunal manage its time in terms of hearings. As many of you would accept, the COVID-19 pandemic affected many of us in terms of our activities. The tribunal immediately took steps by issuing practice directives. You recall the COVID-19 practice directives. It developed protocols around virtual hearings, and the tribunal was able to adapt, come up with shortcuts, and fast-track its processes. And the tribunal was able to be more flexible in its procedures and to tailor these to the competition cases that were before it at the time. This year, we've returned to the office, but are likely to keep some of the innovations that we've introduced during COVID. So in the coming few weeks, we will be issuing a new set of practice directives, which will spell out when we will hear in a public session a case and when we will have a virtual hearing. This is all aimed at making our processes much more expeditious, but also flexible. For myself, the next few years I think will be interesting years. Recently, the tribunal completed an assessment of the effectiveness of its structure in delivering on its mandate. I understand that some of you in the room may have been involved. Certainly, the Association of Competition Practitioners was contributed to the review. We have finalized the review, and thanks to the association and its inputs, we will be making improvements to the tribunal processes. Again, thank you to Bowmans for the opportunity to share this perspective. I know it's limited to South Africa and the Competition Tribunal, but I do understand that there are lessons to be learned from a comparative perspective to many of you in the audience. Thank you, and thank you for your time.
So once again, welcome, ladies and gentlemen, to our annual African Competition Law Conference. We're very excited to have you here. My name is Lebohang Mabidikani. I am one of the partners in the competition practice at Bowmans. I'm based in the Sandton office, and I will be moderating this panel discussion. So our topic this morning is regulator objectives and procedural fairness. And so we're going to have a very exciting debate with the assistance, of course, of our esteemed panel that I'm going to introduce shortly. So when you think about the concept of procedural fairness, it's a very important concept in African, or rather in merger regulation in general, right? And this concept is important because it ensures that the decisions that are rendered by the competition authorities are not only transparent and fair, but also, you know, it's one of the tools that ensure that the parties to transactions have legal certainty. Now, when you think about procedural fairness, one shouldn't think about it just in the context of the actual merger assessment. I mean, as practitioners and business and other stakeholders, we start grappling with this idea of procedural fairness even before we file a transaction with the competition authorities. You know, we think about issues like whether or not the requirements for a merger filing are unduly burdensome, for example, especially in the context of non-complex transactions. And we'd also think about the cost of compliance, the cost of actually getting a merger filing submitted to the competition authorities. And again, I think that question generally comes up in the context of non-complex transactions. I suppose one could justify some of those costs when it comes to complex transactions that are likely to take up a lot of resources from the competition regulators. But certainly we've come across these questions in practice where clients would be asking us whether in fact it is worth paying, for example, R500,000 in order to get a very simple transaction through. Now, because of the importance of procedural fairness, one, there needs to be clear rules and guidelines around, these issues. For example, one needs to understand the approach of competition authorities to information exchange. There needs to be clear rules around whether, in fact, or rather around how the parties' rights, the party's right to be heard is going to be practicalized. So, for example, if there's any concerns that come up in the merger assessment process, either from the regulators or from third parties, exactly how those processes would be, or those concerns would be dealt with. And of course, most importantly, parties must be afforded the opportunity to fully respond to any concerns and of course challenge any evidence that the competition regulators are relying on in making their decision. And well, I don't mean to go on too long on this because, as I said, we've got an esteemed panel that's going to help us, debate these issues in more detail. So I just want to introduce our panel. We've got Mr. Judd Lurie, who's my fellow partner at Bowmans, and Judd is also based in the Johannesburg office. And then we've got Mr. Lufuno Shinwana. Lufuno is Senior Legal Counsel, Competition and Data Privacy, Africa Zone at AB InBev. And then we've got Miss Bertha Mwarija, who's a Senior Associate at our Tanzanian office here at Bowmans. And of course, Dr. Willard Mwemba, who is the CEO of the COMESA Competition Commission. And finally, we have Mr. Thomas Janssens, who's the head Antitrust, Competition and Trade Group at Freshfields. Welcome to all of you. Thank you very much for agreeing to have this conversation with us. So maybe I'll just start with you, Judd. I mean, from a practitioner's perspective, what is the most pertinent issue that faces procedural fairness in South Africa in particular?
Thanks, Lebo. So I'd like to make a general remark. If you have a look at the International Competition Network's guidelines on merger notification and review, they speak to procedural fairness in a number of contexts. And procedural fairness, as Lebo mentioned, it starts before you even notify. As well as during the notification process, parties need certainty, they need transparency. And the ICN recognizes that this is a cornerstone of any merger control regime, and I agree with that. It really is fundamental that a regime operates in a manner that promotes procedural fairness in order to ensure that it's got legitimacy. Procedural fairness also extends further to items such as the timing for a merger review. How long does it take to get approval in order to allow parties to implement within a reasonable time and get the deal done? Filing fees are also a major consideration, especially across Africa, where the filing fees can be substantial. I'm working on a transaction at the moment where the transaction, as Lebo says, you've got to look at how complex it is. This is a non-complex transaction. And yet the filing fee in one particular jurisdiction is going to be $1.6 million. So that factors into parties' decisions about whether or not to invest and whether or not that is procedurally fair. As regards your question specific to South Africa, I think the most pertinent issue facing South Africa today is something that Derek Lotter spoke about earlier. And those are the public interest provisions that were introduced into the Act and the way in which they're interpreted. And particularly at the moment, the most topical provision is that when assessing a transaction, the competition authorities, from a public interest point of view, need to look at whether or not the transaction promotes a greater spread of ownership by historically disadvantaged persons or by workers in firms in the market. And importantly, insofar as the South African Act is structured, the competition authorities look at traditional competition factors. So does the merger substantially lessen or prevent competition? they also look at these public interest factors and they carry equal weight in the analysis. So from that point of view, it's key to know what the approach is. The ICN also speaks to consistency in the merger review process and that there need to be consistent in certain processes so parties know what they're dealing with. Insofar as this provision that I've just mentioned is concerned, what's happened is that the Commission has interpreted this as imposing a positive obligation on merging parties. That is, in each and every transaction, there needs to be positive empowerment outcomes. And the approach of the Commission in that regard is, in all transactions that we're dealing with, we get a request from the Commission, and the request from the Commission is, we would like the parties to impose an employee share ownership scheme, and that employee share ownership scheme needs to be for 5% and subject to certain design principles. Now, irrespective of differences in interpretation by the legal fraternity, which is that this is not a positive obligation, it's one factor to assess, and one public interest factor is not more important than another, versus the view of the Commission, what needs to be realized, especially by the Commission, is that a one-size-fits-all approach is not necessarily appropriate. What needs to be looked at is whether or not there is a deal-specific harm which needs to be rectified. So it's not even a one-size-fits-all, it's not even a one-size-fits-most. You need to look at things on a case-by-case basis, as opposed to a blanket policy decision by the Commission. I recently watched a hearing last week where the tribunal asked the Commission, what is the magic behind the 5% number? What is the magic behind these design principles? And is this a positive obligation? And it's not something the Commission could answer other than to say it is a policy objective. And that is a laudable policy objective about introducing, especially things like worker ownership into the market. But at the end of the day, we do need some sort of consistency in approach. We do need some sort of understanding. And key to me from an issue of procedural fairness is that the Commission's analysis of a transaction has to focus and has to be based on the analytical framework in the Act. And what that analytical framework says is that the Commission needs to look at whether or not a transaction is capable of being justified on substantial public interest grounds. And the pertinent question that then arises is if a transaction is neutral to empowerment outcomes, or if it actually doesn't have any effect on empowerment outcomes. So in circumstances where you've already got an existing employee share ownership scheme in place, in those circumstances, is it reasonable to ask for further shares and that those shares be allocated to employees? And I think the answer has to be no. In circumstances where there may not be any positive obligation, it's one factor for the Commission to consider. It's one factor to consider, does the transaction substantially harm the public interest? And as I say, in circumstances where there is no negative effect, especially on competition factors, especially on the other public interest factors mentioned in the Act, it may not be appropriate to request that these types of schemes be introduced. And particularly, procedural fairness dictates that we have to be fair to merging parties. Black shareholders in particular need to be able to sell out for maximum value. And there's definitely been a recognition by the Commission and by the tribunal, even before these amendments, that that needs to be the case. And there's also a recognition that you can't in each and every single deal replicate that shareholding if that shareholding moves out of the target firm, particularly where that target firm is significantly empowered. But my real concern is that where this is a policy approach, where there may not be any application or interpretation of it, what then happens is, going forward, especially in the context of our international clients, we advise them beforehand that this may be a request. What then happens from a negotiation stance is that what I foresee happening actually is that international firms or other local buyers may say to existing shareholders who may be empowered, listen, we're going to have to concede to introduce an employee share ownership scheme. We anticipate that it's going to cost us this many rands, and accordingly, we need to discount the purchase price. And that ultimately may harm shareholders. And it's key to get that balancing act right. I think the tribunal is trying to set precedent in this regard, but as Derek mentioned, it's also up to the commission to work with merging parties, to work with the ACLP, which Lebo chairs, which is the Association of Competition Law Practitioners, to get this right and to introduce some sort of procedural fairness so people know this is the consistent approach. And if there is a diminution, what do you need to do to rectify that? Is 5% the magic number, or are there other things you need to offer to counterbalance negative effects?
Yeah, very interesting, Jed. I mean, I'm just listening to you. It seems, and I only thought about it just now, just listening to you, that there seems to be a bit of a blur between substantive fairness and procedural fairness. And because, you know, you're raising these concerns around approach, right? It seems to me that we sort of have to go back to the drawing board and think about what is the problem that we are trying to solve, and then try and sort of separate that question from the steps we're going to take in order to solve that problem. But just hang 10 there, because I want to have a few thoughts from Lufuno. So Lufuno, just having listened to Judd, what has your experience been, overall experience with procedural fairness, as you know, from the perspective of business, and in particular during the assessment of the merger transaction?
Thanks, Lebo. I think, as Judd already alluded, procedural fairness is crucial to the credibility and legitimacy of the process. And when advising business, and I mean, you become accountable to the board, they want to know exactly how a transaction is going to play out. And we need to be able to provide them with sort of key factors which will be considered, how these will be considered, and how it's going to play out. And obviously, this comes to light when considering issues such as timing. And in particular, in South Africa, we've seen what is termed mega mergers take in excess of a year to become completed, which obviously has various timing implications and implications for the target business, which sometimes may be in distress. So that is a big factor to consider as well. Secondly, it would be consistency. I think Judd alluded to this as well. Consistency in approach. Another word would be predictability, where we're aware of how a regulator is going to respond to certain types of issues. This informs business and how we prepare and how practitioners prepare those merger notifications. And I think there's a lot of cost that comes with preparing a merger notification, filing, and certain instances where the merger is complex, there are economists that are used. So there's significant cost. And I think business is on board. We're there, we're ready to provide as much information as possible to make sure that the deal goes efficiently. But we also need that sort of buy-in from the commission and the regulator at hand to cooperate and get us to a point where the deal can get through in a timely fashion. I think the final point I'd like to make on this is also equal treatment. I think we've also seen a number of mergers that have come in where similar issues come up. However, there's a difference in approach depending on who the parties may be. So that is also something that needs to be considered and needs to be consistent in the way in which regulators deal with, particularly with respect to conditions. When those are determined, that there's a consistency in approach and the precedence that is set is considered and applied in a consistent fashion.
Yeah, that's very important. I mean, I'm going to put a thought out there to the panel. I don't want to put anybody on the spot. I want you to think about what I'm about to say. So as a former regulator myself, I can see the regulators saying, well, it's not possible to sort of have rules for every other scenario that you could potentially come across. So where do we draw the line? If you say, you know, there's issues of consistency, should I as a regulator be making rules for complex transactions, non-complex transactions, semi-complex transactions? So I just want to put that out there and for you to think about. Maybe we'll come back to this later. I see Willard is smiling. He thinks I'm making his case for him. I'm not, Willard. I'm going to make sure that they answer. All right. Okay, perfect. So Bertha, I mean, and maybe before I go to you, Bertha, just tell us, Lufuno, have you had different experiences in different jurisdictions on this issue of procedural fairness? And also please speak to us in the context where you may have been one of the parties to the merger, or even as a third party intervener.
Yeah, so on the issue of intervention and third party intervention, I think important to note that, you know, a merger review process in testing whether a merger will result in a substantial external competition is an exercise of trying to see into the future. And when you're doing that, you need to have the inputs of various parties in the merger. While doing so, you need to balance timing and expediency of doing so. So it's quite a balancing act that a tribunal will have to employ. So making sure that all relevant parties are heard, but also making sure that the deal is not delayed. So in particular in South Africa, there are clear ways in which a party could intervene in terms of Section 53 of the Act. And there's a process which is set out. And there's quite a number of precedents which speak to what needs to be considered for third-party intervention. In some of the other countries in Africa, however, it is not so clear as to how intervention can take place. So in Kenya, Botswana, and Namibia, for example, you have merger hearing conferences where parties can raise their concerns in a public forum, and merging parties are then allowed to comment on those. However, it's not a process where you're ultimately intervening formally, where you're able to adduce evidence as well as question the information which has been provided by the merging parties. So I think that's something where we can see improvements or maybe changes in legislation in following the South African approach, where you are in a merger process before the tribunal allowed to adduce evidence if you're let in, cross-examine witnesses, as well as get access to the record, which is then important if you are a third-party intervener in order to test what the merging parties have put up and contribute meaningfully in aiding the tribunal in its assessment. I think importantly there, a body and a regulator needs to have discretion as to who to let into the process, because you don't want it to be a free-for-all. You don't want it to be a forum where people are trying to raise their agendas. I mean, in the recent Platinum Implats case, the Competition Appeal Court there indicated that intention is not necessarily important in assessing whether someone should be let into a process. However, what should be considered is whether they have experience in the market and can add valuable knowledge to the tribunal's assessment. Further to that, their role is not that of an amicus in being a friend of the court, but really in providing expert knowledge of the market in aiding a tribunal in its process.
Yeah. It's funny, actually, I thought about that transaction. As you may know, Bowmans acts for one of the parties in that transaction. But anyway, I think that's a topic for another day. We'll probably have a whole conference about what happened in that matter. But I think you touch on an important thing, and I think I don't want us to lose sight of it. We're trying to almost have a comparative study of who's doing what better. But in our experience, at least in that transaction, what was quite interesting, particularly in relation to the judgment of the CAC in that transaction, was that the CAC almost acknowledges that the tribunal has discretion in determining who to let in and to what extent. But then the CAC then goes back and says, well, in exercising your discretion, you were too rigid or something like that. So go back and think about this. So I think what I'm saying is that it looks to me like even where there seems to be a set of rules, those rules or the enforcement of those rules does not come without its challenges. But again, I think we'll just put those thoughts out there, and maybe even the audience, you can engage with us on those thoughts a bit later. Moving on to you, Bertha. So please speak to us on your experience in Tanzania on procedural fairness and how this has impacted merger regulation in Tanzania.
Thank you, Lebo. So in Tanzania, the watchdog for merger regime is the Fair Competition Commission, which deals with all mergers that are filed or applications that are dealt with from Tanzania mainland. And then we have the Zanzibar Fair Competition, which deals with any merger that affects businesses in Zanzibar. Now, for both regulators, the Fair Competition Act provides for specific information that is required, for example, where a person wants to intervene in a merger. But the challenge that we see now is that some of these third parties would wait until the application has been filed and approved by the Fair Competition Commission or the Zanzibar Fair Competition Commission, and then they'll go to the tribunal stating that they had issues where time had already lapsed. So in a case like this, you find that parties spend a lot of time now dealing with the third party's intervention, which could have been dealt with before when the application had been filed. And the second thing that we see as a challenge is there is no change of control definition in the Fair Competition Act. So this results into having parties have filed an application, but then the FCC or the ZFCC, when determining or reviewing the application, they say you needed to file 3 or 4 additional applications. So this ends up frustrating parties in terms of the timelines because each application will be dealt with separately. So these are some of the challenges that we see from the Tanzanian perspective.
Oh, wow, that's quite interesting. So just to be clear, Bertha, what you're saying is you are seeing parties or third party complainants essentially not coming out and engaging with the authorities during the process. And then suddenly once a decision has been made, then they basically want to reopen the issue and raise concerns. Is that what you're saying?
Yes, that is correct.
Yeah.
So for example, in a case study that it's a case that we're dealing with right now. So the parties had applied for an application to for approval of a merger, and the Fair Competition Commission had approved the application, but there were certain conditions that the party were not happy with. So they had appealed to the Fair Competition Tribunal to those specific conditions, which would make business very difficult for them in Tanzania. So when the Fair Competition Tribunal is dealing with that objection or the appeal, we had 3 or 4 third parties, interveners, who went to the tribunal and they said that they were not happy and they did not they were not given a chance to actually participate in the application when it was heard by the FCC. But the rules are quite clear that the FCC is required to publish a notice to invite third parties to participate, and it's within 14 days. So the notice was already published, but they did not object. Now that the tribunal is dealing with the actual conditions in the approval that parties are not happy with, the process has to start again, because now these 3 or 4 interveners, they have to be listened to, the principles of natural justice. You have to listen to them first and then go to the substantive issue, which is the condition in the application.
Yeah, that sounds tough. No, I think I speak as a practitioner. I don't know what I would tell the client if something like that happened to me. So, but or it happened to the transaction. But yeah, I'm scratching my head. So, and you're saying that these third parties are not challenged about why they missed the publication, the notification. Was there any dialogue around their obligation or their responsibility in terms of having, having the obligation to respond at the time that the transaction was being assessed?
So sadly not, because the tribunal would have to deal with, they need to listen to them. They need to know what the concerns were first, then rule out that actually you did not have the right to, intervene at this stage. But they take that as an opportunity to, delay the transaction because they're not happy with the merger. So this is a bit of a gap in the law in Tanzania, which, needs to be rectified so as to prevent, situations like this. So in this case, there are 3 applications. So the tribunal has to deal with one after the other. But what they did was they decided to consolidate all the 3 applications and then rule out that you actually did not have the right, to appeal at this stage because these issues were already dealt with the Fair Competition Commission. But at this point, you have wasted 3-4 months, which is very frustrating to, business owners. Yeah.
Yeah, that's quite interesting. Okay, Yeah, we'll probably come back to you a bit later on this, but I think a lot of people will probably have some questions. Moving on to Dr. Mwemba. So having listened to Judd and Lufuno and Bertha, Willard, do these challenges sound familiar to you at all? And you know, if so, what steps do you think regulators need to take in order to enhance procedural fairness, particularly in the context of what we've just heard from the three panelists?
No, thank you so much. And I'm just thinking here, listening to the three colleagues, that regulators are in deep trouble. and that I'm the only regulator here speaking. So yeah, but I'll try to be very careful, not to be not to alienate more my colleagues. But look, indisputably so, procedural fairness is very critical, not just in major assessment, but in antitrust cases as well. And as I was coming here this morning, I tried to look at the definition of procedural fairness, official definition, so that we all understand what procedural fairness is, but what are the elements? So I tried to look at them and see if the COMESA Competition Commission is actually living up to those. And the first word I saw there in procedural fairness is that the process has to be fair. So I was saying, but procedural fairness, the definition is that the process has to be fair. So I conveniently chose to ignore that first part. And I went to the next one. It said the process has to be impartial, meaning you shouldn't be unbiased. I mean, you should be unbiased. Then the next one was giving the parties the right to be heard. And then the other one, the last one, was giving reasons for your decisions. And I looked at these, with the exception of the first one. I looked at all these three and I said, well, I think we do that. And I said, I think I'll be able to face with a very straight head the lawyers here, mainly Bowmans, because I'll be able to tell them that, Derek, you remember we did that? That is procedural fairness. Tamara, you remember we did that? That is procedural fairness. So when I looked at that, I said, we do this. Now, the thing that is on my mind, or the thing that I'll say, is that having rules laid down, because people are saying, let the things that the commission do be clearly laid down so that everyone knows that this will be the process. That is a very important aspect of procedural fairness, but not sufficient. To me, what is sufficient is the attitude of a competition authority. You may have all those things clearly laid down, and not, but is that competition authority following those things? So it's the attitude of the competition authority that matters more than that. And I think what we've done at the commission is to work more, at the COMESA Competition Commission, is to work more on that attitude. For example, I heard Judd say, sometimes because of certain processes, certain rigidities, you tend to discourage investments, right? Because merging parties, for example, will say, well, it's so burdensome to invest in that, to merge in that jurisdiction, so I'll simply not go there. Okay, so at the commission, for example, the attitude thing that I'm talking about, it's very clear to everyone that when you're dealing with a transaction, it's very clear to everyone that when you're dealing with a transaction, you're dealing with people's money somewhere. And the more you hold on to that transaction, the more you affect other processes. And we clearly understand that the competition authorities are only one tiny dot in the bigger scheme of arrangement. So we shouldn't be having this behavior as if we are the omega and the alpha. Everything begins and ends with us. Competition authorities, sometimes I see there's that attitude, but there should be that recognition that we are not the only ones, we are not the only regulators dealing with that particular transaction. So the more we move with efficiency, the better. So it's very clear for us, all the staff, and some of you have dealt with them, you can attest to that, that we try to resolve those matters as fast as possible. Secondly, I'm still talking about attitude issues because before I come back down to what is laid down at the commission. Secondly, we listen. Okay, we've listened. We've issued so many guidelines. We've issued so many practice notes. One of the practice notes was issued just this Monday on how we interact the interaction between national competition authorities, the merging parties, and the COMESA Competition Commission, because we saw there was a problem there. So we issued practice note just on Monday. So we issue several practice notes to try to address gaps because we listen. We also quickly drop those practice notes when we realize they've caused more problems than we wanted to resolve. I recall we had one with Derek and I think Lita where there was this issue of what does the word operate mean in the COMESA competition regulation when it says a transaction is notifiable when either the target firm or the acquiring firm or both the target and the acquiring firm operate in 2 or more member states. So there was an issue of what does that term operate mean? And we tried to explain that in a practice note, but then it brought more harm than good. And Derek had all sorts of these questions and we realized that was a problem. We dropped it down quickly and we are working on it to make sure that we improve on that. So it's the attitude attitude issue. Sometimes competition authorities would also say, well, we are the enforcers, we are the regulators, we know it all. So we don't listen to the other guys. The more you listen, you simply refine your law and increase credibility of your own institution. So as we listen, okay? Now, going to the issues and laid down that guarantee procedural fairness in our system. First of all, as I've said, we issue these guidelines and practice notes where we make it very clear as to the meaning of certain terms, okay? So it's very clear to everyone else. Secondly, from even before the transaction is notified, judge to give you comfort. For us, even before the transaction is notified, we have quite a number of very open engagements with the parties, open conversations. We are available, at least one may attest that we are available almost all the time. Emails, it's an attitude also. A lawyer or a emerging party sends an email to you asking for what they should do in this circumstance. Sometimes people I see certain competition authorities, they say they have their own lawyers or they know the law. Let them read the law. I'm not their advisor. I find that, yeah, I've seen those things and I found those things to be very worrying. At the commission, at least we strive to respond to those emails as quickly as possible. I think I used to be very good some 5 years ago. I'm not so sure I'm still, but my colleagues are still very good at that. And then, then the other thing, when there are concerns in the transaction, before we submit that transaction with our recommendations for decision making, because remember we only investigate, then we make recommendations for another body to make a decision. When there are concerns, we comprehensively address the parties, trying to address those concerns. And in the past, I heard a number of competition authorities will be saying, how come the COMESA Competition Commission has never prohibited a major? And my answer would be, there's nothing fun in prohibiting a major, because once you do that, you're just frustrating investments in your jurisdiction. There should be everything to look at to salvage or save that major. If there are concerns, address them with the parties, and the prohibition should be the last resort. So it's not that we've not had majors with significant concerns. We had one, I think I'll mention it later, very significant one. We've had a number of them. I don't know if Dr. Dano is here. We had the, yeah, he's there. We had the Kenya National Shipping Liners Major and Kenya Ports Authority. I think there were several concerns. There are several red lines there that on the face of it, the major should have been prohibited. But because we had comprehensive and frequent interactions with the parties on how to address those concerns, which concerns were significantly addressed, the major was approved, everyone was happy. We're talking about a port in Kenya, Mombasa. There's lots of business that is going on there. So if you're casually sitting in your office and say, well, because I'm a regulator, I'll casually say, I've prohibited the transaction. You don't know so many other stakeholders who will be affected as a result of that prohibition, which could have been avoided. So for us, we engage the parties quite comprehensively, quite significantly, even in the process of the major review before we arrive at a decision. Once we arrive at a decision, also ourselves, or a recommendation, I'll call it a recommendation, we'll send it to the CID, which is basically the body that makes decisions on our recommendations. If the parties are not comfortable with what we are recommending, we don't stop them from coming to present to that body. Okay, there is no provision in the law actually that says the parties should come and present to that body. But we are saying we want to be transparent. There's nothing to hide, even if there's no provision in the law, and we can simply choose to quietly go to that committee, because it's the committee of COMESA. We can simply choose to go to that committee quietly and present our issue, and that's it, because there's no provision that says Tamara can appear before them. But because we want to be so transparent, we don't want to be forcing our narrative on the CID. We want them to listen to the other guys as well. So where there are concerns and the other guys are not so happy with our recommendations, we tell them, please come and appear before this CID. And even at that CID, despite it being part of the COMESA structure, they've several times disagreed with us. They've disagreed with us. We had this transaction, Derek, I don't know if I can mention it here. Derek appeared in that one in Mauritius, I think about 2 weeks ago. And we had recommended a huge fine. Okay, I'm even embarrassed to mention it here, by the way. But it was a huge fine of about $3.5 million for what? For simply the parties, they did not notify within the 30 days period that our regulations talk about. And then we said, oh, this is the breach of the regulations. We'll fine you a certain percentage of your turnover in the common market. I think we had defined before on that 0.05%. Now, 0.05% was a huge figure, and we were rigid about it. We said this is precedent by the same CID. So when Derek appeared, he made his case there. We tried to make our case. I was looking at the chairperson that day, and I could see he was saying that we disagree with the CCC. But yeah, so they made their presentation. At the end of the day, they told us, and the decision is there on the website. They said the commission was unreasonable. The fine is very unproportional. There is no harm on the market. So we disagree. And the fine was reduced significantly from $3.5 million to about $300,000 dollars. So things like that. But there are also situations, just to conclude, where us have disagreed with the CID because we've thought the CID have been, they've overreached. They've been a bit more intrusive than they should have been. And of course, it was not in a major case, but I said procedural fairness is not just on majors. So we come to an understanding with the parties. We terminate a contract or an agreement worth $1 billion. And then we say, if they do A, B, C, D, we'll close the investigation. And we've just terminated an agreement more than $1 billion. That's sufficient fine in itself when you look at the consequences, because then there are so many other stakeholders who are involved in that. So those guys will have to face litigation somewhere. Yeah. So we say to us, we think we've achieved our goal. The $1 billion contract is terminated. Then they will undertake to do all these things to ensure these things don't happen again. We go to the CID, they say, no, we are not comfortable. In fact, they should be fined on top of this. Well, we say, no, we don't agree with you. Okay, so even us that we've disagreed with them to simply ensure that there's fairness, there's transparency. So these guys appeal against the decision of the CID. Okay, and as they appeal, we go to the appeals board, supporting the parties, because we are saying this is what we agreed with the parties against our own CID, and the judgment comes out in our favor against the CID. And even them, they are saying, well, this is how we build law, so we don't take offense with these things. So there are all those safeguards, and when it comes to decisions, as I've said, there are a number of mechanisms. Derek can appear before the CID. The CID decision can be challenged before the appeals board. The appeals board can be challenged before the COMESA Court of Justice. And all those are things that are very clear when you look at our guidelines and practice notes on our website.
Yeah, no, quite interesting. I mean, I think.
And he talked about filing fees, by the way. You remember some time back, 9 years ago, when I come here, it was this COMESA and $500,000 filing fees and things like that. We listened. Within a year, we had amended that, and people should not look at that as a year. At international level, in fact, not even just at international level, even at national level, amending laws is not that easy. But within a year, with all these, by the time there were 19 member states, there are 21 now, with all these 19 member states who are stakeholders to that, we had to amend the law and reduce the filing fee by more than 66%. Okay, now you can imagine you would go to the countries, I'm just mentioning them by way of example. You go to Zambia, you go to Kenya, you go to Zimbabwe. They will tell you that, why are you reducing the filing fee? we don't agree with you. In fact, as COMESA, because of this filing fee at COMESA level, you should know that we've lost revenue because some of the transactions that would have dealt with are now coming to you. So to convince your stakeholders that this is not making sense, we are losing credibility. In fact, in the long run, we are discouraging compliance with the law is not that very easy. But because we are very transparent and we want to see that fairness, we still manage to do that within a year. So Judd, I think I thought I should say something to that.
Yeah,
Not $1.5 million.
No, this is quite, I mean, I'm certainly impressed just listening to what you're saying, Willard. And this is, I just wanted to put a thought out there, listening to you really emphasizing the importance of constructive engagement between parties and the regulator. Just a thought to put out there, not a question to anybody, but I've actually personally had a recent experience where in engaging with a regulator, the question, we're basically asking questions, you know, we're not sure if what you're doing here is procedurally fair. And the answer was, we note that the parties in this transaction are trying to micromanage the regulator. So there seems to be a need to have a balance, right, in these engagements. But I'll ask you maybe later around how we strike that balance. I just want to move to another point quickly. We understand that certain members of COMESA, I mean, I know in the past, and I'm told there's at least one right now, and forgive me if my intelligence is incorrect, but we told that there's challenges with some members basically still raising issues with the one-stop shop principle, not being willing to be bound to that principle. What is your response to that?
Look, I've heard that. To start with, we have 21 member states, and officially there is no member state that has told us that they are not complying with the one-stop shop. And I've heard some concerns from you, the lawyers. For example, Egypt, I think it's not a secret. Egypt is a country people would say should we notify? And I engaged Egypt several times, and they told me that there is no one who has said they should notify in Egypt. I think to those that I responded to, I would always say, I've just spoken to the Egyptians, and they're saying they don't understand what is happening because they've never, ever asked anyone to notify. So to me, the issue was, and I hope not arrogant and rude, but the issue was that please give me tangible and concrete evidence that we went to this authority. Here is the letter, and they told us that notify. And unfortunately, I think I never saw that. But what is happening now is that Egypt, they didn't have major control provisions then. And I was wondering why that concern was arising, because they didn't even have major control provisions. But what has happened recently now is that they have those provisions. I think to become enforceable, they need some kind of regulations or which has not happened. So they are not yet enforced, but they are there. And once they become enforceable, they'll be able to have an ex-ante major control regime. So maybe there's also this speculation that what will happen then. And it's very difficult for me to 100% say this is what will happen, except to tell the lawyers here and your clients that I've had conversations with the Egyptian Competition Authority on this already. And they have said that, look, we are members of COMESA, that treaty has been ratified. What will happen is we'll still comply with the one-stop shop. But the only thing they indicated to me, which Kenya I think also does, is that the notification, yes, will be with COMESA, but we'll simply ask the parties to notify us of that transaction that has gone to COMESA for us to know. I don't know, maybe they don't trust us that, as they say, for us to know which transactions involve Egypt are being dealt with at COMESA, and Kenya does that as well, not that the notification is with Kenya. So that is the model that Egypt was saying they may follow once they, but we'll see it when we cross the bridge.
Just on that point, how do you then manage the flow of information? Because you also understand that sometimes, even if the national regulator is aware that there has been a COMESA notification, then you have instances where the national regulator is firing questions directly to the parties, notwithstanding that the filing is lying with COMESA.
That's a very good question. And that's a practice note I was talking about, which was put on our website just on Monday. Today is Friday, right? Just on Monday, 4 days ago. Now, for me on that one, frankly, and to be very honest, I thought lawyers and their clients were missing the point. And that's why I said, let's put a practice note so that it's very clear. When we receive a major notification at COMESA, fairness again, so everyone should know, what we do, and we are obliged by our regulations to inform all our member states, national competition authorities, or at least a government ministry that is involved with on competition matters there, of the transaction that involves them. And in that notification, we also ask them to give us any information on the effects of that transaction in their country. So if we are doing that, then it only becomes fair that they have to gather some information in their country. So the issue is when they are gathering that information, they are not getting that information to analyze the transaction, then issue a decision. No, the information that they gather, they still bring it to us. Otherwise, there have been cases just like the Kenya National Shipping Liners that I was talking about, where we have gone into a country to investigate because it has serious issues. But there are other cases, and we don't want to waste the party's time, that we always have to go to Mauritius, we always have to go to Madagascar. Some measures are very simple and straightforward. So we simply gather information through those national competition authorities and analyze. But if the problem I saw, the parties, the lawyers would come to us and say, Zambia is asking us for this information. Kenya is asking us for that information. Egypt is asking us for that information. And my answer, not on the phone, but in my heart, I would be like, yeah, there's nothing wrong. That information is important for COMESA at the end of the day because it will come to us. So what we've done now is we've issued a practice note, which is guiding the parties that, look, when the notification is made to COMESA, it still remains a COMESA notification. The decision will be issued by COMESA. But for us, we have a network that we've created amongst ourselves with the national competition authorities, okay? And they gather that information and give it to us. So if they approach your subsidiaries in their jurisdiction, there's nothing sinister about it. They are simply collecting more information on our behalf. Otherwise, we could have chosen to go into Kenya as we did on Kenya National Shipping Liners and do that ourselves. There's no difference. But we have this network that, and we, in our view, it just brings in a little bit more efficiency and effectiveness. Judd again talked about the time period it takes to review the measure. Our law is very clear. It gives us up to 120 days, but we don't want to exhaust all the 120 days because we have 120 days, and we've endeavored to do that way before the 120 days in most cases. Yeah. But if we were to go to those countries, all of them, to do that on our own, then I can assure you we'll be exceeding the 120 days. So it shouldn't unsettle the lawyers. It shouldn't bring any fears or any uncertainty. The national competition authorities, when they do that, actually it is us who've asked them to gather that information. But what we have done in the practice note also to just avoid duplication and also uncertainty, confusion, and what we've said, when there's that direct engagement with the subsidiaries of the parties in that particular member state, we should be in copy so that we are moving together, because sometimes we may end up raising the same issues that Zambia is raising, for example. So please, you go and look for it on our website, and it will bring a bit of some clarity. I hope, Derek, you will not say there are these other issues, so drop it down.
No, that's clear. Thank you very much. So moving to Thomas. So Thomas, can you give us an outline of what the Europeans have done in their efforts to achieve procedural fairness, and whether there are also any areas of improvement?
Yes, well, first of all, I want to thank Bowmans for putting on this conference. It's really always a highlight. And not only because it's sort of 25 degrees warmer than in Brussels at the moment here, but really the exchange is always super stimulating. I'll start actually by answering the first question you asked, which was about, so do you need sort of rules for everything? I think in a way, the answer is no. That's why you have due process. As long as you have due process, you don't need rules for everything. You can't predict everything, but if you have the right procedures, and indeed fairness throughout, then I think you can deal with things that you can't possibly predict. So I agree with what's been said about fairness being about certainty, predictability, transparency, impartiality, and so on. And I think, I mean, looking at it sort of from European experience, certainly things aren't perfect in Europe, whether it's the European Commission or European member states, or former member states as well, talking about the UK. And I think so you need to look at the issue of fairness at the different stages. You were alluding to that, I think, at the start, whether it's establishing jurisdiction. I'll come back to sort of a recent example in Europe on that. It's then about, once you have notified your transaction, having an unbiased review of your case, for sure. But it's, I think, also in the practicalities, and I mean, I agree with what Lufuno was saying about, in a way, these are not just lofty principles. This is very concrete. You need to sort of, as advisors, whether in-house or external advisors, you need to go to companies' boards and be able to sort of say what will happen with some degree of certainty. I think what's great to hear from Willard about also an authority like the COMESA Competition Commission being humble to some extent, that the antitrust review in many cases is just a small part. Sometimes it's a very important part, but sometimes it's really just a small cog in the whole machine, and you shouldn't have the sort of the tail wagging the dog, whether it's in terms of the timing of the review or the issues or sort of the implications in terms of costs to implement remedies and what have you. Very concretely in a process, I think what's very important, and it's still work in progress also at the European level, is access to third-party complaints, for example. What are they saying? Are they just whispering in the authority's ear, and you sort of get these strange questions all of a sudden as parties? Or do you have a process where actually that is very out in the open as between the parties, and you know what they're saying, you know what evidence they're putting in, you know also what economic analysis, for example, they're putting in, and you can sort of really engage in a debate rather than having to shadow box, because that's when it becomes very, very difficult. I think it's for example also access to responses to requests for information by third parties. Again, so what are they saying? Can we get to see that? Can we get to see that in time to react, or do we need to wait much longer? It's also about exchanges between authorities. Internationally, authorities talk to each other in their review, in their assessment of remedies, etc. How are they each assessing that? And talking about remedies, again, they're sort of having access to the reaction of third parties and having some clear rules as to how those things are being assessed. So I think all of that taken together is quite important. Just at a very basic sort of level of implementing this. I said I would talk about jurisdiction in Europe, and maybe many of you are aware of the case. We've had the whole saga around Illumina Grail. And so that was a transaction which ended up being prohibited by the European Commission, even though it did not trigger the European thresholds for review, nor the thresholds for review in member states. And so until that case, I mean, we have in Europe a system where whether you have to file to the European Commission just depends on very clear thresholds based on turnover. And most member states, not all of them, but most member states have similar rules as well. Some of them still have market share based thresholds. That always makes it a bit more difficult. But so until that case, essentially the European Commission was saying, sorry, I should add, so if you have the European Commission, you have member states, but you also have a referral mechanism. So member states can bring a case that has a relevance beyond their territory can bring it to the European Commission. And there's some procedural efficiency, obviously, in that. But until recently, the European Commission essentially took the view that member states should only be referring a case to the Commission if they themselves were competent to review it. So if the case was notifiable in their jurisdiction. But in Illumina Grail, they sort of made a U-turn, and that was following a request by France, and then other member states joined in. France was not competent to review the transaction. The French thresholds were not triggered, nor the European ones. But France still said, we think you have to look at this case. Why? What was that? Because they considered, and clearly the European Commission considered, that this transaction needed to be reviewed. It was below the thresholds, but it involved, in the European Commission's view and in the French authorities and other member states' authorities' view, a number of issues that really had to be looked into. And that was sort of in the context of the whole debate around so-called killer acquisitions. Acquisitions by established companies, of companies that may have certain technology, certain IP, certain data, that may still be small, may not have revenue yet, and therefore the transaction does not yet trigger the thresholds, but somehow it is felt, at least by the competition authorities, should be subject to review. Long story short, Illumina very much contested the European Commission's ability to review. They went to court. The European Court actually confirmed that the European Commission was able to review. Illumina, in the meantime, closed the transaction, even so taking quite an aggressive stance in that context, but understandably so, because their view was, well, we shouldn't be here in the first place. And it shouldn't be the case that sort of one person who isn't competent refers my case to somebody else who isn't competent, and then sort of two negatives form a positive, and all of a sudden I find myself in front of an authority. But so case was blocked at the end. There's appeals, there's threats of fines for gun jumping, because the deal was implemented, the eggs need to be unscrambled, etc. So that's sort of a whole story to show you just that things aren't as clear-cut and rosy in Europe as you might think from the outside.
Yeah, another tough one. But yeah, okay, this is quite interesting. I mean, I want to, I think you've actually touched on some of the challenges, but I think I'll reserve my last question for you for after we've had a few questions from the audience. I just want to open up an opportunity for the audience to maybe ask some questions, having listened to our panelists. I'm not seeing hands going once, twice. All right. Okay, just put up a hand if you want to. Oh, okay, there's Tam. Okay, can you maybe bring a mic for Tam?
Yeah, well, it's actually a question. It's actually a question from one of the people attending remotely, and it's a question for Dr. Mwemba. The question is, the Commission has a practice of imposing a remedy in mergers, which states that the Commission can review all conditions again in 5 years and make amendments if necessary. This means that remedies can apply in perpetuity. Is this fair?
I was trying to look at Tamara with frown so she doesn't finish that. But she was so focused on the phone she couldn't. Yeah, now, should I?
Yes, please.
I think there's a little misunderstanding there at in fact, it tries to address exactly the concern of the person asking that question. Because what we saw in the past, the practice by competition authorities was that they would issue an undertaking or a remedy or a commitment, as we may call it, and then it would have no sunset clause. It would be perpetual. So they would just say, for example, we did say in the recent Heineken Distill Major, we did say that the distribution, the in-country in Zimbabwe, the in-country distribution system should continue as was pre-major, unless there are other issues of terminating those distribution systems outside the major that has taken place. But then we say this will be reviewed, I think, in 3 or 5 years to see if this condition would still be relevant at that particular time. Okay, because markets change, and you may find that the condition that you've imposed simply become a burden and irrelevant on the parties because markets have changed. They may not even have the power that they have today, which dictated the commission's thinking of imposing that undertaking. So that's why we started putting that 5 years or 3 years. In fact, what we do now, we don't even have to wait for the 5 years. 5 years is what we think is good enough at that particular time when we're making a decision. But we are very mindful. Currently, we also say if the parties have legitimate and justifiable reasons as to why they think the condition should be waived, terminated, or partially suspended, they may still, before the expiration of the 5 years, reach out to the commission to review those conditions. And if the commission is agreeable with them, they may be waived, they may be terminated, or things like that. So unless I misunderstood the context of the question, but actually the limiting of that condition to that time is to avoid burdening the parties in perpetuity when probably the issue is not even there anymore, the concern.
Yes, thank you. Thank you very much, Willard. I'm not seeing hands, so I'm going to go back to you then, Thomas.
It means COMESA is very good, so there are no issues.
That informs my next question, Thomas. What can the Europeans learn from COMESA?
Oh, that's a very specific question. Look, I think what we don't really have is a system, and maybe I'll put it open a little bit more broadly. But we heard about sort of the appeals process and judges being involved, and here also in South Africa, of course, to block a transaction, you go to a tribunal. That we don't have in Europe, actually. The European Commission investigates your case and ultimately takes a decision. Yes, you can go to court, but you can only challenge of that administrative decision, and by the time you get a judgment, it's way too late to sort of resurrect your transaction. So a system where actually sort of the judge plays their role, and that's, I mean, that goes to fairness, that goes to impartiality, is actually, I think, essential at the end of the day.
And tell us a little bit about whether there is a framework for third-party intervention, a formal framework similar to South Africa, like what Lufuno described earlier.
Well, yes and no, I would say. In Europe, third parties obviously play a role in any merger review. They get RFIs, as I mentioned before. They can also complain, but there are sort of different ways of complaining, and it can go from sort of these whispers in the ear of the authority to something more formal. And sometimes, you as merging parties, you don't fully know what is going on, or if you know, you only know very late in the day what they have been saying. And you can sort of go back and say, oh, that's why we were getting all these strange questions all of a sudden. So the process in terms of third-party intervention, I think, in Europe can also be improved.
Yeah, that sounds quite interesting. Okay, I'm going to circle back, unless there are any questions. I'm going to circle back to you, Jad. So we've listened to Willard. I mean. I think you've answered a lot of what Jad spoke to earlier on, and I just want to hear. It was a positive targeting because you're answering questions, right? But what are your thoughts, Jad? I mean, having listened to Willard in particular, and I'm not saying you must answer in respect of COMESA necessarily, but is your position still that there are a lot of threats to procedural fairness in respect to some of the issues that Willard touched on? And if so, what do you think would be the potential remedies to some of these threats?
So I think, and Willard and I have chatted about this before. The COMESA, with having such an open regime and being able to have that dialogue, has gotten it right. But as Willard mentioned as well, you've got challenges across Africa in a number of jurisdictions where you can't engage with regulators or a regulator is new. I mean, what we've seen on the continent is phenomenal. There are so many regulators that have come online, and having those dialogues and inconsistencies in outcome can be difficult. I think, one of the other things that the ICN speaks to is equality of treatment, about whether or not an acquirer is a local firm or a foreign acquiring firm. In a South African context specifically, I suppose, it's not just about asking, and including in African jurisdictions, actually, it's not just about asking about teaching a man to fish. You've got to ask who owns the pond, and whether or not in doing that, it is appropriate to extract more conditions from bigger firms in order to get a deal done. In the COMESA context, as you've explained, the conditions that are imposed are when you think they're necessary and when you think there is a specific harm to be addressed. I think in other jurisdictions that we've seen, it may be the case that there aren't harms and conditions may be seen to be extracted as opportunistic. And what we've seen because of that is that you end up in a situation where parties are willing to walk away from a deal or simply to shut the deal down. We had one example where it was a Tanzanian example, Bertha, where the transaction took over a year to get approved because the regulator wanted the parties to get a license, which the parties didn't technically need. So there are a number of challenges. And I think, as these regulators advance and especially as they become more experienced, they will evolve and we will hopefully get more procedural fairness onto the continent.
Yeah, and in fact, you referred to Bertha. I wanted to go back to you, Bertha. You mentioned earlier that because of these gaps in the legislation, then you basically have a situation that I would refer to as an uncertain regime, right? Because just because a decision has been made, it doesn't mean there won't be an opportunity to reopen the entire process, it seems to me. So when you say that you think there's a need for some legislative reform, do you have any thoughts on what that reform should look like, and how challenging would it be in your mind for that to happen, and how quickly would it happen, just based on your experience?
Thank you. So there is a need to have a reform so that parties know that, I've applied for a merger, I've gotten an approval, and this is the end. Now it's an implementation of a transaction. There is a very, very need to actually have that in law so that, you have more investors, parties are certain about the procedure. As Willard said, it takes a long time to have a law amended. So roughly, I would say maybe a year or two.
So essentially in the next year, there is basically risk that one could basically reopen as many decisions as possible. Yeah, no,
Yes.
I think we are duly warned. But I hear you. I mean, I think I'm taking this really as the panel's last remarks. I'm looking at the time. We don't have that much time left. Lufuno, do you have any reactions to a lot of what Willard has said in particular, because he is the only regulator on the panel?
Yeah, I do. I mean, I was quite encouraged by Willard's stance on the way in which COMESA interacts with parties, and I think we've experienced it as well. And I think it's also on the topic of attitude. I think it's a lesson which I take with where I come from to also encourage business as well to change their mindsets in dealing with regulators and how we approach them, as not a stumbling block, but as a stakeholder which we need to cooperate with. And I think that's something that we can enforce more within business. But I think it obviously needs to be an ongoing dialogue between two parties. I mean, we've also had regulators who have been difficult, and it's been, I think, I'll speak to Derek, and we need to decide when are we sending a strongly worded letter in some instances. And, you know, that balancing act in making sure that you're communicating effectively, but also driving your point across in a respectful manner is a balance which we often have to walk. And I think if more regulators took on Willard's stance of having an attitude of cooperation, we'd all be in a better place.
So the punchline is no alpha and omega attitude, basically. No, but thank you very much. I think this brings us to the end of our discussion. I have not noted any hands, so I think we are basically done. Thank you very much for participating. We really appreciate your insights. Thank you for listening. Thank you.
Good morning, everyone, and welcome to what I think is going to be quite a lively session, talking about national security, public interest, and the trends towards protectionism and preserving local interests. You know, you've got quite a lot of lawyers on the panel and one regulator, but being that, we certainly will not have the session as a complaints gathering session. Because once you talk about national security and public interest, it tends to go south from there. So let me start off by introducing the panel. So I'm Xolani Nyale, a partner in the competition practice of Bowmans based here in Cape Town. To my right is Heather Irvine, who is also a partner, but based in Johannesburg. And then we've got Joshua Mwamulima. Okay, I got that right. Who's a senior associate in our Lusaka office. And then on the far right, we've got Mr. Azumpeleli Langalanga, who is a non-resident fellow at the Mandela Institute for International Economic Law at WITS. To my far left, you have Dr. Adano Roba, who's the acting DG at the Kenya Competition Authority. And then right next to me on my left, you have Mr. Juan Rodriguez, who is the co-head of Sullivan and Cromwell's European Competition Practice and Antitrust Group. So an eminent panel, and in that eminence, I include myself. Especially. You know, got to give yourself some credit now and again. So the panel, we've got about 75 minutes, which will be split as follows. We'll have each person having 5 minutes opening remarks. Thereafter, we'll have a conversation as between the panelists, and of course, we will also open it up for questions from both people who are joining online and of course from yourselves. So I think to start off with, let's perhaps start with the regulator on the panel so that he feels the warmth and love of this panel because amongst friends here. So Dr. Adano, I suppose it would be great if you could talk us through your understanding of sort of the parameters of public interest in merger control, and from a philosophical lens, sort of how far should policymakers and regulators go in intervening in broader public policy objectives in merger control? And are those public policy objectives always clear and well understood? And also what it is that you're trying to solve for?
Thank you very much, Nyali. As you clearly heard, I'm based at the Competition Authority of Kenya. We are a national regulator, not like the CCC based in Lusaka. Our main mandate as a competition authority is to look at competition and also consumer protection. We have dual mandate in Kenya, unlike maybe South Africa, where we have two agencies which are not under the same umbrella. From our perspective, public interest considerations is another layer of competition assessment, which sometimes seems to conflict with competition assessment. But in our view, it really adds a lot of value in terms of public considerations, meaning that what government considers to be important in terms of policies and public policy engagement, it becomes very clear that government has a wider concerns about what role competition can play in the national context. Within our law, which actually is what defines what we do, we have 4 parameters that we normally look at when we are looking at competition assessment. And therefore, the additional layer will always cover employment as a national concern. In terms of merging entities and in the analysis, what are we looking at? We look at the establishments of those agencies and see what are the establishments as of them, and see when they merge, what will be the outcome. Will it result in laying off some of the workers? In that analysis, what we find to be very challenging from our perspective is that we often say retain 80–90% of employees post-merger in that case. The 80–90% employment that needs to be maintained seems to be arbitrary in most of the cases, and that's one of the areas that we see as challenging from our perspective, because we need to be very discreet and also very predictable in terms of what parameters are we using to assess that competition, and what public interest consideration are we giving, and what are those numbers that should be maintained by parties. That's one. And the other aspect is, given that we are largely SME-based economy, we do look at what's the role for the SMEs in terms of merger, and therefore what are the relationship between merged entities and any SME that might have a relationship with the parties that are merging. So we do take care that the low capital trap that often available with the SMEs is also taken care of in our analysis. The third parameter that we also consider is the competitive international market also, as we look at what are the best benchmarks for parties that are merging, and how does that condition relate to best practices outside Kenya. So that's the third parameter. And the fourth one that we often consider in public interest is research and development. How competitive are entities in the market, and therefore what are the best options for them to deliver technical efficiencies. So those are the 4 parameters that you consider, and those are also in the law to allow us actually enforce, because whatever we do has to be defined by the law, and therefore there is no possibility for us to implement any provision, whether it's public interest or any remedy that are available to in that particular context, for us to say this is what the law defined, and therefore we have a leeway in terms of going out within the provision of the law. So that has to prevail, and that provision has to be stipulated in law. And of course, there are other discourse around there, whether we are actually an employment bureau as a competition agency. So that's one of the sentiment we often get, that we are not an employment bureau, but I think there's bigger public interest concern and also government economic agenda that overrides what we do. And therefore, we do see that moving forward, competition assessment actually has a significant role for citizens when public interest issues are considered, provided they are within the remit of the law. Thank you.
Okay. Thanks, Dr. Adano. Heather, I suppose let me turn to you. So, I mean, Dr. Adano has mentioned that in Kenya, there's sort of 4 factors that they consider. And I suppose South Africa, from a public interest perspective, there's 5 stated in the law. Is your experience that 5 is in fact just the 5 as written in the legislation, or there's some scope creep? Sort of how do you advise your clients to navigate the public interest debate in South Africa?
Yeah, thanks, X. I think it's interesting to think about how our public interest provisions in the Competition Act are applied by contextualizing them within a framework. And fundamentally, the policy direction comes from the Department of Trade, Industry and Competition. In May 2021, the minister published a competition policy for jobs and development, in which he specifically identified localization, in other words, buy local, as a very important factor for stakeholders. And he included the Competition Commission, of course, in that term. And this has undoubtedly had an effect on the application of the public interest provisions in our Act, but also has found its way into a range of other policy measures. So, for example, the Competition Commission has published guidelines on the implementation of the Sugar Master Plan, which includes a localization element. They've published some guidelines on competitor collaborations, trying to assist South African companies to collaborate in order to buy local. And then we're seeing this localization concept being baked into the sector master plans. And then, of course, followed up by enforcement in the merger context. And our Act enables this because one of the factors is the impact of a merger on a particular industrial sector or region. So we have increasingly seen conditions being imposed on merging parties, which require them to increase the number of local inputs that they buy, or to further develop their supplier base. And of course, all of this is happening in addition to the efforts which are being applied under the empowerment legislation. So there's been a big push towards this. But I think it's important to think in our context about whether these kinds of conditions, for example, we've seen them in telecommunications tower mergers, in the MTN IHS transaction, for example, they undertook that they would procure products and services locally. In a number of retail mergers, we've seen a replication of the textile master plan commitments that merging firms have to buy local. I think it's important to think about the nature of these conditions and whether they're really achieving the broader public interest impact of the Act, and also having effects on competition. And to not just impose those, someone on the panel earlier talked about a one-size-fits-all approach, but really to think about, are these transactions where that's really appropriate? And the groundwork for that was laid in the Walmart transaction, you might remember, where the minister intervened and based on a particular effect, the disruption of the South African supply chain, sought to have a range of conditions imposed on the merging parties in that instance. There was no suggestion that this would become a kind of a request which is posed to all merging parties in all industries, regardless of the actual impact of their transaction. And I think the danger is we're now starting to see these sorts of conditions being offered as an alternative. So there was talk on the previous panel to the request that we're seeing increasingly that parties will actually increase HDP ownership as a result of their merger, or alternatively implement an ESOP, an employee share ownership program, for more than 5% of the shares. And increasingly, we're starting to see localization type conditions being offered in lieu of those sorts of conditions. And then I think one has to think very, very carefully in order to craft conditions that are appropriate to the parties' transactions. So will buying more locally necessarily improve the position of the business to make it stable, to enhance its competitiveness, put it in a position to be able to support and grow employment, which is a fundamental policy objective, obviously, in South Africa at the moment? Or is it just loading commitments onto a business which is functioning in a very difficult part of the economy? Is it a business which is particularly affected by our current energy crisis? Is it actually an industry where there is any local supply available? In the context of the renewable program, for example, we've seen localization requirements becoming a serious barrier to the implementation of successful renewable energy programs, simply because these kinds of inputs are actually not available locally at all. So I do think we need to start having a more nuanced debate about why we need these conditions, and even when we do impose them, ensuring that they don't have knock-on effects which are unintended, or alternatively, which actually undermine the central purpose of the Act, which is to foster competition in South Africa.
Thank you, Heather. And then I suppose, whether it may be a subset of public interest is also what was introduced at the same time as 12 capital A3E of the Act was section 18A, I think, capital A, which is the national security provision. You've been an observer for some time. on the trends and sort of what policymakers have been trying to achieve. And so, good or bad, what's your take on what the potential impact of the implementation of the national security provision could be on investment into South Africa? And as someone who's sort of written quite extensively on this, in your view, to the extent that you've seen any potential pitfalls, what would be your advice to policymakers to try and remedy it before they even, started implementing the law?
Yes. No, thanks a lot. So the national security provision is more, not a subset. I view it as more of another layer, because what you have with the national security provision 18A, capital letter A, is that you then have government saying there will be sectors of the economy that are deemed to be strategic, and also that are deemed to be essential, and also those that are deemed to be key to the function of the economy, but that may not, are sensitive sectors that cannot be left to foreign companies. So with the way the way Section 18A is crafted is such that the president has to constitute a committee of ministers and other maybe senior officials, and this committee will have to look at investments as they come in, and make sure that if they feel like that if a company is coming to South Africa and let's say it wants to invest in Transnet, for instance, and that company comes from let's say it comes from a country that is deemed to be hostile to South Africa, and you cannot leave the company to run Transnet, then that foreign investment will be sort of prohibited. So this is not something new. Basically, this was responding to what has been happening at a global level with the emergence of China and the idea of state-owned companies going abroad to invest in key sectors of other countries. There was a sense that this might infringe on the sovereignty of another country. So it's a way of trying to deal with that. But the way it has been done in South Africa is that it has been taken away. So it's, for some reason, it's put in the competition framework, but that power of the Competition Commission is taken out, because basically what the committee of the president will do is that it has more power than the tribunal and the commission itself. So I in the past I've been involved in sort of screening of investments, but for foreign governments in South Africa, where South African companies are going on the outside to invest, so where the screening, how it's done practically is that you get a sort of a you get asked to look at the ownership of this company, like proper ownership, not on the face of it. Maybe look at the directors, also their links to other maybe sensitive companies or sensitive governments and things like that. Then you just say you are not going to allow it if it's a. How it differs from public interest is that it's difficult to provide a reason. The whole idea of transparency and all other these things, it doesn't really apply when you deal with national security. So, and because of that, it lends itself to potential abuse in a system that is already opaque. But where it really serves a practical a practical purpose is where, for instance, during COVID-19, the whole idea of security showed us that it goes beyond the traditional idea of understanding of security, because, for instance, we had issues of security of supply in the health sector. So you can, as a government, you can then say you want healthcare companies that come into South Africa to be companies that you are sure that when push comes to a shove, they will really ensure that there is security of supply. The other case where we saw this was, for instance, in Transnet, there's an issue going on in Transnet, which on the freight rail, where a Chinese company invested there. They provided the locomotives, but for some reason, or because of the findings of State Capture Commission, which implicated that company, that firm now is refusing to supply South Africa with or Transnet with spare parts. And this is really compromising the ability of Transnet to provide services. So these are the kind of issues that this national security provision is really meant to address. But like I said, it really depends on the good faith of the people that are applying the national security provision.
Sure. I suppose, yeah, because there isn't much transparency and not much by way of sort of a feedback loop to the public. I need to apply for a job there. Goodbye, Derek. So, Juan, of course, your authorities refuse to be outdone, right? And they've come on board big time, right? Both in the UK and Europe. And I suppose we shouldn't be saying both because it's UK, Europe, and then individual member states, right? So there are multiple layers to this. So just talk us through, I mean, what is the current landscape in Europe, and what are the emerging themes and trends, and also obviously practical tips. Just before you start, I should just mention that there's some handouts on your seats. Those accompany one's speaking points.
Excellent. Thank you, Galani, and thank you very much to the rest of the Bowmans team for the privilege of participating in this conference and having at least 3 days escape from the vile Northern European winter and substituting this captivating view. If you see me looking in that direction, don't take it as a slight on you, but I just find that view totally seductive looking out there into the bay. Anyway, so is Europe outdone? No, I think the key message here is that really there's been nothing short of an explosion in foreign direct investment regulation in Europe and the UK in the last 3 years. The landscape today bears no recognition at all to what it would have been 3 years ago before COVID. If you look at the regimes that there are, and it is a patchwork of regimes, there's no sort of one-stop shop like we have for merger control, although there is some loose and opaque coordination via the European Commission that I'll speak about in a moment. If you look at the Europe now, you see that of the 27 member states, 18 have got their own FDI regimes, 7 will adopt FDI regimes before the end of next year, and then you'll have 2 countries which don't have them and have no prospect of having them, namely Bulgaria and Cyprus. So the map really it's quite covered if you look at it in countries that have these regimes. Now, each regime has got its own substantive standard, and I was very interested in hearing the discussion we've just had because they are opaque, and the concept of national security, which is meant to be the review standard, is not defined. Frankly, in some countries, intentionally so. They want to keep flexibility because what's national security today may not be national security tomorrow, and so that can oscillate depending on the mood of the day. And it's great for lawyers, frankly, but it's highly frustrating for business and for deal doers, because these rules don't just catch the obviously sensitive industries like defense or critical infrastructure, gas grids, electricity grids, but all manner of products from the experience we've had as acquirers, Counsel in doing these filings, pharmaceutical products that are not blockbusters, but products which for one reason or another, a member state thinks are important. Another example, maybe sounds ridiculous. There's a case right now going through the European Court of Justice. It's the first litigated case in relation to the EU regulation in foreign direct investment. It's a Hungarian case. What were the products that were sensitive there? Sand and gravel. Sand and gravel. Okay, Hungary's landlocked. They've got no beaches. So maybe they are dependent on sand, but sand and gravel. And if you look at the logic that the authority used to prohibit a transaction, it was essentially because the transaction, so said the authority, would prejudicially affect small and medium-sized enterprises that were already in a bad financial state because of COVID. That sounds awfully like industrial policy to me and not so much national security. But I think that illustrates part of the problem, that there is this definitional deficit. There's a lack of precision, which means you don't really know what the authority is going to go after. Some people say, well, it's just like merger control. It's just another regulation layer for mergers. Well, yes and no, in the sense that, first of all, unlike what I understand to be the case in Africa, it's not the competition authorities that enforce this stuff. There's an intentional institutional separation. It's the various parts of the economics ministry that tend to have responsibility for these rules, not the competition authorities at all. We tried that in the UK. It didn't work very well, under our Enterprise Act. But in any event, there's no one-stop shop. Frequently, we're now finding that transactions give rise to more of these FDI notifications and processes than they do merger filings. There's sort of been an overtaking of merger control by FDI. We should perhaps rename our group the FDI and also Antitrust Group rather than the Antitrust Group, because in some instances, honestly, FDI is the prevailing type of work that we are doing. Remedies. What happens if the authorities don't like what you are doing, but they want to give you a chance to remedy it? Typically, these are behavioural remedies, sort of like you see in South Africa, keeping certain assets and technology in the country, not allowing non-nationals to get access to technology, periodic reporting, keeping supply agreements substantially in the same form as they are pre-transaction. Again, that sounds a little bit like industrial policy to me. Don't put your prices up. Do ensure that you're continuing to trade with the counterparties you've been trading with before the transaction. Opaque, I heard the word opaque. I mean, this is the great word that sums up the processes. Again, unlike competition law enforcement in Europe, these processes happen behind closed doors. There are no published decisions. The parties get a decision of sorts. In the UK, it's one page, typically one paragraph, but there's none of the transparency and the body of wisdom you have with competition law in this area. It's intentionally opaque. By the way, in the UK, they don't even tell you the names of the case handlers. They think it's a matter of national security to know who the case handlers are. So you're not going to go and try to suborn them in some way. Again, not very satisfying from a practitioner's and a client's perspective. Noticeable increase in remedies we've seen in the last year. The authorities have really stepped up wanting to have these remedies, partly because of the cooperation mechanism. So what is that? So each member state has got its own rules, but we have an EU regulation, Regulation 452 of 2019, which in a very loose way attempts to create some sort of unity. The most important provisions of that regulation from a practical perspective are Article 6 and 7, which set up the so-called cooperation mechanism, which means that every member state that receives an FDI filing sends it to every other one. And that's got two practical effects. First of all, because the authorities coordinate in this way, there's a sort of a, how to put this politely, cross-fertilization or maybe cross-contamination of ideas, okay? You file in 4 states, everything's going well, and then one of them has a problem and tells the others, and the others think, oh, I hadn't thought of that, actually. Maybe it's a problem for us as well. So we'd like some undertakings. That's one major problem of that regime. The other is, if you're not filing in a particular country, if you've done your analysis and you think they don't need to file, you better be sure that's right, because it is known for authorities in states where filings haven't been made to pick up the phone and say, we heard about your deal because it was filed next door. Why didn't you file it with us? Two very important practical points. Lastly, on Europe, things are going to get more invasive because we've got a thing called the Foreign Subsidies Regulation, which fully enters into force in October of this year, which will create a whole new scrutiny regime for foreign subsidies. Great for lawyers again, but really not helpful for people doing deals. Lastly, then, on a few observations on the UK. So we have a new act in the UK. Of course, the UK has got to be different. It can't do things in the same way as continental Europe. We have a new act which entered into force on the 4th of January of this year, National Security and Investment Act. Practical takeaways for that are it is different. The triggers for intervention are much broader than under the European regimes. The triggers can be shareholding percentages, 25%, 50%, 75%, can be the acquisition of voting rights, and can also be the acquisition of so-called material influence, which is a concept borrowed from our merger control law. And that can be almost whatever the authorities want. You know, a 10% shareholding, the ability to put one person on the board, maybe even as an observer, a non-voting observer, that can be material influence. Very, very broad so-called call-in powers, even to the point of being able to attack transactions that are not really M&A. It's quite a famous case of a technology license granted by Manchester University to a Chinese academic institution. Well, the authorities didn't like that. That was called in and that was prohibited. Pure technology license. What's happened in terms of prohibitions? There's been 6 prohibitions and 9 conditional approvals. The conditional approvals you read about in so-called notices of the orders. You don't see the whole order, but you see a very, very concise summary. So you get a bit of a gist for what the conditions were. Practical takeaway, Chinese and Russian acquirers. Those are the ones who are in the spotlight. All the prohibitions bar one were in relation to Chinese acquisitions. The one non-Chinese one was a Russian-backed company. So a few practical observations. As I mentioned earlier, this FDI screening has become almost a predominant type of regulatory control on mergers now in Europe. Many cases, particularly for PE buyers, involve more FDI than they do antitrust. PE buyers in particular don't like this because quite often they have to disclose details of shareholder structures and limited partnership structures, which can be quite complicated, and even have to disclose the identities of their limited partners, which can put them in quite a difficult position. The cooperation mechanism that I mentioned, that certainly had practical consequences within Europe, not always helpful from a practitioner's point of view. The other thing, which I think probably doesn't apply, at least here, where I understand the competition authorities can unilaterally impose remedies. In Europe, that's generally not the case. Generally, you offer remedies if the authorities like what you want, if what you offer, they will clear your deal. If they don't like it, they prohibit it. FDI authorities can unilaterally impose conditions. You offer something, they don't like it, they say, tough, this is what we want, your clearance is subject to that. That's got quite an important knock-on effect for transaction documents, where you sort of go back to how it used to be in the bad old days, where definition of the conditions precedent now, to take care of that, need to mention that the approval has to be on terms acceptable to the buyer. Otherwise, you as the buyer can end up being saddled with obligations that you never envisaged you would have to live with. I think I probably exhausted my time with that.
So I suppose for once, our neck of the woods is looking reasonable. Right.
I mean, in terms of transparency, you know, you have the guidelines in South Africa. You've got case law going back a long way. That's none of that is accessible in Europe.
Yeah, no, it feels good to be reasonable once. I suppose, you know, just to close off on this point before we go to Joshua's opening remarks is I mean, Azu, what does one do when your client is caught up in this national security review?
You are at the mercy of the regulators. In South Africa, you'll be on the mercy of the committee, because the decision of the committee cannot really be subjected to another authority, because this is really national security. So there's legally that you can actually do.
Right. You sort of just wait it out.
Yes.
Okay. Joshua. So I mean, unlike South Africa, where our new dawn did set very quickly. In Zambia, under HH, it seems that it's staying its course, right? So we've recently seen, you know, tremendous speed from the government in replacing the board of the CCPC. You know, what is the CCPC's focus on public interest? Do you expect that to change now that there's the new board in place? So if you could just talk us through that, and also whether is there an overlap between the CCPC's public interest mandate and that of the CCC in circumstances where a transaction has been notified to the CCC?
Thanks very much, X. That's right. I think the HH government has stayed on course. And you can see that there's so much investment interest in our sector in Zambia. And I think yesterday, the Zambian Commission published their annual report, and it does indicate that certainly there was so much interest in Zambia, such that there's a 25% increment in terms of the major application we've seen. So there you can see that we are moving in the right direction. With respect to public interest consideration, I think Doc had mentioned, similar to Zambia, that is prescribed in the law. Actually, it does requires the commission to subject all major application to a public interest assessment. And in terms of the consideration, that is also kind of prescribed in the law. And we look at things such as the extent to which the proposed transaction is likely to benefit the public. In terms of that, it's kind of left to the commission to decide what amounts to the benefit to the public. You've got other considerations such as the extent to which the proposed transaction is likely to result in the transfer of technical skills to Zambians. Other considerations include the extent to which that proposed transaction is likely to promote the growth of exports from Zambia, and more importantly, promotion. Other consideration you're looking at is the proposed transaction likely to help a failing firm. If that's the case, that's something which they'll take into account. So from there, you can see that the commission has discretion, or the considerations are kind of broad in terms of what they can decide in terms of a public interest. But from what we've seen, it's that the commission is highly unlikely to just prohibit a transaction on the aspect of public interest alone. What we've seen is that they all approve the transaction, but impose conditions linked to public interest. And I've seen that's a trend, I think, since from 2010, they haven't done that. Only thing they do is to impose a public interest consideration. And the main conditions are usually two. One, to maintain local contracts, supply contracts with locals, and employment. I think that appears to be very key. Because the consideration are prescribed in the law, we think that the new commission is likely to take that route. And then here, I think we have to commend the government in terms of the speed at which they moved to replace the board. It also shows the importance government has placed in terms of this institution. It's got certain timelines which it needs to within to achieve the certain things. So it was very important that that was done. Moving on to the regional aspect, the economic activities of Zambia are certainly subject to the COMESA competition regulations. But from what we've seen is that interaction overlap between the Commission and the Zambian and the CCC, it doesn't present much conflict. I think, and I'm happy that Dr. Mwemba mentioned that. I think that practice is kind of very helpful in terms of clarifying that position. So what usually we see is that if a transaction has been notified at a regional level, the Zambian Commission is involved. And as part of its submissions to the CCC, it has to advance its public interest assessment. And here I think I can point a recent example which involved a merger of two banks, Atlas Mara and Access Bank. It's there on the Commission's website. So because it's involving a merger of two banks, both the Zambian Commission and the CCC did acknowledge here that that transaction had no impact of lessening any competition. But I think from the Zambian aspect, that stressed or expressed fears that that transaction was likely to result in job losses, especially in places where both companies had physical operations. But nonetheless, the transaction was approved on the basis that both parties undertook that post-merger, the employment status will remain the same, except of course for management position where there's a risk of duplication. Yeah. On the aspect of national security interest, that's something which is yet to arise in the Zambian context. So we'll see how the Zambian Commission would deal with that. I think for Zambia, the closest it came to, I think there was a transaction which had to deal with the merger between the Zambia National Broadcasting Corporation, this is a national broadcaster, and Topstar, it's a Chinese entity. Members of the public expressed fears that allowing a foreign entity to own a stake in a national broadcaster would lead to an aspect of security concerns. But nonetheless, that transaction, I think, was approved mainly because Topstar had advanced a loan to Zambia National Broadcasting Corporation. And I think one of the conditions is that once that loan is repaid, the ownership has to revert back to Zambia National Broadcasting Corporation. Yeah. So I think to conclude, XCA is that what we see in Zambia is that a merger is unlikely to be prohibited on the grounds of public interest alone. There must be something else. And therefore, for prospective acquirers, it's important to note that chances are that once a transaction has been approved, conditions to do with maintaining local supply contracts and employment, that condition is likely to be there. I thank you.
Super. I suppose, I mean, what I'm getting from the panel is that at least, you know, in South Africa and East Africa, and of course, Southern Africa with Zambia, there's an understanding of what public interest is. Yes, there may be scope creep, but at least there's an understanding. And the question, I mean, these tend to be sort of bread and butter issues in our neck of the woods. The question, I suppose, will be whether that clarity of thinking will then permeate to the national security provisions as they come into effect, or whether we will be fumbling as our colleagues in the UK and Europe. I must say, I'm enjoying this this change of role, right? So, you know, we may have something to teach you guys. You know, but perhaps, you know, I mean, it took time, right? It took some time before all of us understood what public interest is and what its rightful contours are. I think let's pause here to just check if there's any questions from the audience or from people who are dialed in. Not sure who's reading the things online. Yeah, we've got a question there.
Thank you. My question is just about public interest generally, just to hear from anyone on the panel, and maybe setting aside the foreign direct investment question and national security. But going forward, what is the role of merger specificity realistically going to be? And do we think that that's something we actually want to hold on to, or are we now in a world where that's actually not front and center of how we assess public interest, particularly in mergers? So just commentary on merger specificity and what is the role of that going forward?
Want to go for it?
Maybe that question I was thinking. It says, thank you. So he says the Topstar ZNBC issue. And I think you are trying to relate it to national security issues and the like. But that even when there was public outcry by that this would raise national security issues, the transaction was still approved on the basis that Topstar had loaned ZNBC some funds, and then that ownership will revert after the loan is repaid. So in relation to the question that he has posed, is there not a danger there that actually even it's good it was approved, obviously the parties would have wanted it to be approved, but is there not a danger that actually that was not a major specific approval? That's how it sounds. I don't know what your views are. Thank you.
Yeah.
Certainly in South Africa, merger specificity remains the guiding principle. And that's both in terms of competition effects and also in terms of public interest effects. And that I think is very important in an environment where we have, suffered the ravages of state capture, have an ongoing serious corruption issue and a serious lack of trust between the citizenry and the machinery of the state. It's absolutely critical for the integrity of the Competition Authority and of the process under the Competition Act that this is evidence-based decision-making. So we have to identify effects both on the competition side and on the public interest side, and we have to then apply conditions which are directly responsive to those effects and importantly proportionate to those effects. So one can't, for example, say this is a transaction which leads to a 1% reduction in black shareholding, but we demand a 500 million rand development fund that supports small enterprises. There's no real relationship between those conditions. What we could potentially do is say, well, this is a business in a part of the value chain which is absolutely critical for supplier development. This is an area where there can really be some commitments made that are meaningful, that would be helpful to foster small business development. And we think that that's a reasonable condition to impose in the context of this transaction.
Sure. I wanted Dr. Adano, whether you want to say something on this question.
Well, in terms of public interest consideration, I think there are also other instances where public interest consideration are imposed outside the competition space. Particularly, we have seen in access to government procurement, we have seen that happening. And also recently, not perfectly under competition, but also under buyer power provisions. We have seen that SMEs are being supported by multilateral support, multinational companies supporting their engagement with them by ensuring that their contracts are predictable and also employment continue being provided to the citizens. So there are instances where that seems to have happened, but not entirely under competition. But also there are also instances where we have seen that national security in terms of telecom companies have not been able to merge because initial government investment in that sector has really influenced the decision of the authority, how that should be finally decided. So what has happened in that case is that other agencies come in terms of intelligence, seeing that the government had invested, and therefore, given that Kenya has high penetration rate of mobile, there could be issues around risks, not only to the financial sector, but also in the security sector. So there are instances where there's ambivalence in terms of what should be considered. But I think we are only able to enforce to the extent that there are provisions in the law that allows us to do certain things. But if there are issues that emerges moving forward, I think we still need to see that that is incorporated in the amendments of the law so that we are able to have powers to avoid any litigation from the lawyers. Yeah, thank you.
Thanks, Dr. Adano. Joshua.
Thanks for that question, Doctor. Though I see this case for me, first, I agree that it's a danger in the sense that for parties, it's very difficult for you to kind of predict in terms of the conditions are going to impose, especially such a clause, which requires you to sell your shares later on. I think for parties, what you want to plan for is to have that long-term investment and into that company. But looking at this case, on the other hand, I think to manage public perception, I think there was need to have such a condition that everyone knows that actually this transaction is a result of the loan, because the members of the public didn't have sight of those loan documents. So it was very difficult to believe that, yes, this Chinese entity will just be here for a short period of time. So the only confirmation we had, I think this is this decision from the CCPC. So I think that helped in terms of managing the public perception. Yeah, those are my views.
I suppose, I mean, for me, the question, I mean, the African Union met over the last weekend at those beautiful Chinese funded headquarters. And so the question, I suppose, for the panel is whether we could see national security in the competition protocol that is currently being debated within the African Union, so under AFTA, and also at regional level at COMESA, and what that might look like and what that might mean. Azwi, do you have any thoughts on that?
Yeah, so I really have on that side of the CFTA competition protocol. Okay, but yes, but the whole idea of national security really is done to address geopolitical and geoeconomic considerations. So it's not clear if on the African continent that thinking is really properly permeated. I mean, if I'm listening to the case of Zambia, where you can have the Chinese investing in a public broadcaster, that's the total no-no in a proper market where they understand national security from a geopolitical and geoeconomic thing. But what nationals, in the beginning, it was really to deal with China. But now what it seems to be happening is that national security is being used to advance industrial policy. Because what is happening and what will happen as we go forward is that in the climate, in the renewable sector, governments will be required to kind of put money there to support their own companies. So there will be sort of a protectionist approach where they will use national security to make sure that it's mostly their companies that benefit from the renewables. And I'm not sure if South Africa will adopt the same approach, but if you look at the EU, for instance, they have the Green Deal where there's a lot of money being put there. The Americans have it's called the Inflation Reduction Act, where they poured in billions of dollars to fund their own companies to come and produce new technologies, dual-use technologies and renewables. But we are not sure if South Africa is thinking along the same lines. But really, if South Africa is thinking along the same lines, what will happen is that there is a part of Section 18A, which talks to social and economic development. You can always find creative ways as government or as a regulator to allow or to prohibit foreign companies coming in to invest in the sector, or put conditionalities that make sure that the subsidies or the funding that comes from government is not totally going outside.
If I may abuse my platform, because I have powers to do so, is to check with Dr. Mwemba, because in the room, on national security within the COMESA context, and whether is that thinking starting to permeate there as well? Are there any conversations at that level that are taking place? Okay, that's always good at least on to know at a regional level nothing is happening. I think we've got sort of 10 more minutes left. And there being no further questions, I think I'll just allow each member of the panel to 1 minute concluding remarks, starting with Dr. Adano.
Yeah, thank you very much. I think national public interest considerations are extremely important in competition enforcement, and also linking our agenda for competition regulation to economic agenda of the government. But I think in terms of security component, it often takes place at contractual level between government and government. Therefore, often is also away from the purview of competition agencies, because we are being funded by the same government. Therefore, it's as you always know, it's difficult to regulate your parent ministry or any institution. So therefore, I think it's important to a certain extent. But also in terms of the example I gave with regard to telecom companies, it becomes clear when the government investment is huge, and also the indirect implication in terms of effect of that decision might have security implication. So therefore you get government support, not directly in the traditional way we analyze competition, but when there's clearly indirect effect in terms of the effect of that merger on competition and also national security.
Thank you. Juan?
So I think from a practicing lawyer's perspective that there are a number of red flags to think about. When does public policy and industrial policy start to be camouflaged as national security? Because that's sort of what we're seeing in Europe in some cases. Legislation that was meant to protect security is undoubtedly being used for public policy type objectives, maybe because the boundary is unclear. Secondly, in Europe, if anything, there's a drive away from transparency. The authorities want these procedures to be opaque, and that's not helpful for lawyers and people having to advise on the feasibility of transactions. The fact you don't get reasoned decisions that are made public, the fact that, with the exception of France and to some degree the UK, you don't have proper guidelines like you have here for public interest factors, not a helpful factor. And I do think you made a joke out of this, but I think there's truth in what you said. To some extent, the European regimes do have something to learn from how you've done things here, at least in terms of setting up the regime and giving transparency on how it's being administered.
Super, thanks. Let's go that side and you, Azui.
So I think in South Africa, we tend to be very skeptical of government. So I think when this national security provision, when it comes into force, it'll be good for government to kind of communicate a message that shows that first, this is an international trend. Secondly, that there will be an element of transparency as far as is allowed in such a provision. But also maybe to the competition lawyers. I see there's some colleagues here from you guys work closely with economists. But I think with the national security thing, you'll need to also work with political scientists to kind of preempt what kind of issues that the transaction might actually trigger, especially on the public policy side and also on the industrial policy side.
Just to follow up, that's an interesting point, because we've seen two sort of reactions to this problem. The first is, I'm not saying it necessarily works, but the clients will get in somebody like Kroll to do a sort of a reputation audit to try to model the risk. Not sure that does work, but gives them some comfort. And the second thing is you can actually now buy insurance against certainly UK NSI risk. There are brokers out there who will sell you insurance, just like you can get insurance against reps and warranties in an SPA, you can now get insurance against an adverse intervention by an FDI authority.
For the insurance companies in the room, a new line of business. Joshua.
All right, thanks. I think I'll conclude by aligning my thought with something Dr. Mwemba indicated, and that is of timelines. When these conditions are imposed, for how long do the parties have to comply? So for us, I think what we're seeing now is that they're imposing a period of at least 1 year and a further requirement that the parties should submit a report indicating their compliance requirements. So far, we haven't seen where parties have been fined for breaching their major conditions. But I think as of yesterday, it was interesting to see that in concluding remarks, the Commission indicated that they've now a unit just dedicated to checking that parties are complying with their conditions. So it will be interesting to see now going forward how that will play out. Yeah.
And of course, I think the CAK is that's something that sort of has had for quite a while. We certainly have had transactions where a couple of years later, you receive a very nice letter from the authority. Because there, unlike in South Africa, where the reporting mechanism is built into the condition, it's not built into the condition. And so a couple of years later, then the regulator sort of does a compliance audit.
Yeah.
And you're like, oh, well, I thought we both forgot about it.
Yeah.
And nah, they haven't forgotten. Heather.
Yes. So my final thought is that these kinds of protectionist localization type conditions in merger control in South Africa are undoubtedly here to stay. And our foreign investment controls will come into effect at some point. And I guess the challenges for the lawyers involved, their clients, and of course the regulators is to ensure that these are applied in a way which continue to give the message that South Africa is open for business and investable. And that's got to be true not only of course, of foreign investors, but also local companies, because they have options now. It's not only that they can invest their piles of cash in South Africa, there are continental options under the free trade agreement increasingly, and of course, global options. So we need to craft conditions that are effective and support the aims of the competition legislation or honor the intention of the foreign investment controls, but at the same time ensure that deal making can happen, because that's at the end of the day what drives economic growth and fundamentally job creation.
Yeah. No, thanks, Heather. And I think, of course, underlying all of this is just also about understanding the trade-offs, right, that we have to make, and also who bears the costs of all of this. So to the extent there's protectionism, you talked about the IHS MTN merger, localization, does it increase costs for consumers ultimately at the end of the day, in fact, or not? So that draws this panel to a close. Thank you, everyone. I'm told that we will not be taking a break. We will move into the next panel right away, so that we can all end a bit earlier and go for lunch. Thank you.
Okay, still morning, so good morning, everybody. Great to see so many of you here, and it's a privilege for us to speak to you today. My name's Tamara Dini. I'm co-head of the competition practice at Bowmans, and I'm joined by a very esteemed group of panelists. I will introduce them starting from the left. Ms. Siboni Selizulu Maseko, Acting Manager of Enforcement and Exemptions at the COMESA Competition Commission. A big welcome to you, Siboni. It's much more comforting to see you in this forum than on the other side of a screen when you've got a lot of questions to ask. And next, a gentleman who's already been introduced this morning, Thomas Janssens, the Global Head of Competition and Antitrust at Freshfields. Welcome again to the second panel, and thank you, Thomas. My partner, Joyce Karanja from our Kenya office. It's great to see you, Joyce, and we've had you participating not for a couple of years now, so thank you. Thank you, interested to hear from you. And then former Bowmans partner and one of my favorite ladies, Ms. Khomolemo Kakezi. She's the head of markets and competition, as well as regulatory affairs at MultiChoice. Welcome, Khomo, and thank you. And then finally, a gentleman who needs little introduction, Mr. Makali Mashlashla, head of cartels at the South African Competition Commission. I saw that Makali actually joined the commission in the year 2000, so it's almost 23 years of being in enforcement, which is quite an innings. So welcome, everybody. Our panel discussion focuses on behavioral investigations in Africa and shifting the scrutiny from vertical arrangements to cartels, where it still seems a lot of the difficult work needs to be done. So merger control, of course, has often been the starting point for new regulators, and a focus in African competition law regimes. Several regulators have expanded on this focus to behavioral conduct, but many still focus largely on vertical arrangements. So what we're really interested in today is trends in investigations into conduct, and a shift in the scrutiny of relationships of a vertical nature to investigations into cartel conduct. I'd like to put a first question to Joyce, speaking in her Kenyan hat, not necessarily as a COMESA hat for this one. So Joyce, Kenya has taken a very strict approach to vertical restraints, in particular vertical exclusive arrangements, which in certain other jurisdictions are not necessarily seen as problematic and are often seen as pro-competitive. Now, is there the strict approach to vertical restraints in Kenya being maintained? And in practice, is it possible to actually use pro-competitive benefits to offset perceived anti-competitive effects in a vertical arrangement?
Thanks, Tamara, and good morning, everyone. It's really nice to be in Cape Town. So yes, that is the case. I think historically, and as far as vertical arrangements are concerned, the authority has always taken issue with exclusivity agreements. And there's many examples of how they've gone around sort of addressing the issue. One of the early ones is Kenya Breweries was asked to actually remove exclusivity provisions from all of its distributorship arrangements because the authority said that they were anti-competitive. And interestingly, as far as vertical arrangements are concerned, it seems that soft enforcement seems to be the way the authority has tended to go, requiring the parties to either remove the offending provisions from the agreement. And I suppose the starting point in the Kenyan legislation is that a restrictive trade practice is prohibited unless it's exempted by the authority. And the way the act is worded, generally speaking, the starting point is it is the authority who has the mandate to determine if the agreement that you have in place is, is a restricted trade practice, right? You can't, you never used to be able to self-assess. And things have progressed since. The authority in 2019 issued block exemption guidelines, which have given parties the ability to self-assess their transactions themselves, but they're very limited in scope. So they actually cover 3 or 4 types of agreements, one of which is a franchise agreement. And even there, the exclusivity parameters are quite limited in scope and duration. Also, the branding of stadiums and sports promotional and marketing events, those are also kind of exempted. You can self-assess to see if you meet the criteria set in the Act. And also agreements for exports, generally speaking, those are not covered by the exemption. So I think the position does remain that even where the authority has to receive an exemption application, they will have to take a number of factors into account, including whether or not the pro-competitive outcome of the agreement outweighs any anti-competitive issues arising from it. And if I give a couple of examples, a few years ago, there was an exemption application that was lodged by Wow Beverages. And what they wanted to do was have a vertical agreement with exclusivity from 7 different wine and alcohol distributors bringing alcohol into the country. And they argued it was necessary for protecting consumers from defective products, and also for them to be able to, protect their investment. And the authority declined to give the exemption, saying that actually other competitors in the Kenyan market should be able to bring in and import products from these same manufacturers, and that ultimately consumers would benefit from more broader supply. So they actually rejected the application. So I think the other thing maybe that's worth mentioning, just pre-COVID in around March, the authority issued an order to manufacturers of what they termed as essential products. At that time, it was face masks, sanitizers, and maize flour, those kind of things. And it actually just gave a public order telling them to all delete exclusivity provisions from their distribution agreements. So I think it does remain the case that the authority does look at them still strictly as being anti-competitive. They are required to balance the pro-competitive outcomes from any public interest benefits, but ultimately they look at it on a case by case, and the trend seems to be generally that they are viewed as anti-competitive still.
Okay, well, good to know.
Yeah.
Interesting. Thank you very much, Joyce. Turning to Siboni. Siboni, at a regional level, it was came as quite a surprise that the COMESA Competition Commission's second behavioural investigation actually focuses on allegations of horizontal conduct. Are you able to share with us if there are other behavioural investigations anticipated or even underway at this stage?
Thank you, Tamara, and good morning to everyone. And just to start, Tamara, I'm very happy that you specified that it was a second behavioral investigation, because I think there tends to be a little bit of a misunderstanding that the COMESA Competition Commission hasn't had any enforcement investigations to begin with. And so, yes, we do currently have behavioral investigations ongoing. We have them in the beer manufacturing sector, and we have them in the shipping sector as well. These are, publicly made known on our website. And I think what's important to highlight is that we work very well with the member states. We've been on the ground in several member states. We've been to Kenya, we've been to the DRC, we've been to Mauritius, we've been to Seychelles and Zambia as well. So we work really well with the national competition authorities to collect information, to collect evidence in order to pursue our investigations and to come to an informed outcome. And I think what will be interesting in terms of where the Commission is, looking at the behavioral investigations we have ongoing, makes me think of Professor Ngube's opening this morning, where he spoke about a more reasoned decision, that it's taking the tribunal slightly longer to issue decisions because they have to be more reasoned, because you expect a challenge. And to this end, we are quite pleased as the Commission that, the appeals decision that was issued by our appeals board in December compels our committee for initial determination to issue a reasoned decision. And this is, it's helpful not only to our stakeholders, but it's helpful to the investigators as well, because then we have precedent and, we know where we're going in terms of our assessment, in terms of what our adjudicators are going to take into account. And so, of course, when you have a behavioral investigation, you can expect a challenge. That goes without saying. So it gives us comfort that as a jurisdiction, we are moving towards giving more predictability in our decision making as well. And we have that our appeals board is now saying, if you're going to issue a decision, then it has to be reasoned, it has to be well researched. And that is, of course, it's going to assist us in our work going forward. So in terms of any other investigations that are anticipated, it would be folly of me to say that in this particular forum. Yeah. Yeah.
Thank you, Siboney. That's all very good. I do have some questions for you that I might want to come back to later, but just want to first check in with Khomolemo from a business person's perspective and from advisor to the business. We're seeing increased scrutiny of behavioral conduct in general in Africa. And I'm interested, and I'm sure the audience as well, as to how this is perceived or experienced by business. On the one hand, you may feel that greater scrutiny keeps competitors in check, keeps your suppliers in check from not engaging in cartel conduct. Interested in your thoughts on this increase in scrutiny.
Thanks, Tammy, and I really appreciate you seating me right next to the kingpin of cartel in Africa. And good day, everyone. It's good to be back home. Nice, friendly faces that I've missed for many years. So I think increased enforcement of behavioral conduct necessarily implies increased awareness, and this is both from business, such as our company, being aware that enforcers are looking at what companies are doing, but also I think from a public awareness perspective, where, the media in particular will pick up on prosecutions of high profile cases, and the man on the, ground, in respect of whom I think competition law is intended to protect, takes a keen interest in what is going on. So as a principal perspective, I think it really does help focus the mind of business on competition law. But just to give you a flavor of how it translates, to a company the size of ours, and I have to caveat it because my boss is here. I speak as an individual and not as multi-choice from my learned experience in practice and within the company, although does help. So multi-choice is in about 52 sub-Saharan countries, which pretty much covers the entire continent. And what this really has meant is that we're caught by the EU law, were caught by regional competition authorities like COMESA. Some of those regional competition authorities have the same members. So if you're in one country, you've got more than one regional competition authority to worry about. Then we've got national competition authorities. What are we at? About half of the continent has about competition laws, and the number is increasing each year. It's good in a sense, but it does also focus the mind on, the extent to which you've got to focus. And then we're in broadcasting, which necessarily means we're a regulated sector. So a lot of you will know that you've got sector regulators that enjoy concurrent jurisdiction on competition matters with competition authorities. It's not just about pure licensing issues. So you need to get a license, etc. They also have the power to look at markets, look at whether competition is effective in those markets. Is there a dominant player or a player with market power? And typically they have the power to impose ex ante conditions, which they will link to the dominant player. And so you see yourself being required to share a piece of your pie, which you've invested tremendous effort in money, resources on with smaller guys. And there's not always an interrogation of, are those guys not growing? Is the market not changing? Because firms are just inefficient. There's not enough of that technical interrogation that you would expect, from those regulators, specifically because it's the competition authorities that really do have those expertise. And then, of course, the lay of the land is changing by the hour. We've got the AfTA, the African Free Continental Trade Area, which itself has ambitions, as we've heard earlier, to regulate competition in the free trade area, which is quite a huge area. So all of that means we've got a vast array of laws to be mindful of and to comply with. And I think because of the sheer size of the company and the fact that it's listed on the JSE, our reputation is everything. But it also means we're at the forefront of both our competitors, customers, suppliers, and our beautiful regulators. They love us and we love them. The issue is not really with the extent and the degree to which competition laws are growing and increasing by the day. For me personally, as a ex-practitioner and also as an advisor to business, it's the manner in which these laws are enforced, right? There is complete divergence of approaches, same conduct, similar issue, whether it's exclusivity or whether it's cartel, might be looked at completely differently. I think to take a step back, in fact, the basis on which authorities approach us and want to investigate, that standard is very different. In South Africa, we've got case law, at least, that says you must have a reasonable suspicion that's founded on objective information. That's all very nice English. But the reality can be trickier when you try and probe what actually has led to this concern. Is it legitimate, or has there just been a JSE announcement and an article that picks something up that piques the interest of authorities? That sometimes is a battle to kind of get over the line. Whereas if there was a common materiality threshold for when regulators should take an interest in particular conduct, bearing in mind how many operations we've got, bearing in mind what it would mean in trying to comply with all the regulators and the requirements, it would help. I think it would buffer the level of scrutiny that we are experiencing on a day-to-day basis. Then obviously the jurisdictional overlap, not just regional authorities, national authorities, and sector regulators, necessarily means compliance with everything costs quite a bit of effort and time and money. And I think the bigger risk for us is a conflict of decisions. So one conduct could be with a higher standard, okay, but with a lower standard, not so okay. But the conduct is being undertaken by the same entity. And so you kind of, should we not, is there a middle ground? And ultimately, I think I'm advocating for a convergence of competition law principles. I mean, these are all well-known universal principles, but their application and the way they're coming through in the law, but also in terms of the approaches of the different regulators, is not convergent. It's very divergent. So if there was a deliberate effort by regulators to have uniform standards and principles through the likes of the ICN and the different collaborations that I know agencies undertake, it would simplify the life of businesses that operate across the continent. And so I suppose for us, what it means is that the cost of compliance is very high. I do not come cheap, ask my boss. But just the number of complaints and issues that we have to deal with and the number of experts like economists, and now we're told political science, but hopefully we're not in the national security sphere, is also going to be, is constantly an issue. And the time and effort to comply is quite significant for us. But maybe let me end it off by saying, for a company that prides itself in terms of the business that it does, the consumers that it reaches, cooperation with agencies, because of the amount of time and effort we spend chatting, trying not to scream at each other, Machalia and I and COMESA, cooperation is first prize. Cooperation is first prize, which is why predictability, certainty, uniformity in approaches would help. And litigation is the last resort. But of course, because of the lack of deference that at least I see regulators showing each other, an appreciation that if I get bitten from the COMESA side, other regulators will see that I've been bitten and perhaps I did do something that was not appropriate in terms of the COMESA regulations, that's actually going to inform how I approach the exact same issues in every jurisdiction, because it makes no sense for each jurisdiction to take its own course. So we really do, we know regulators are watching. And so everything that we decide for one business unit has to be replicated across most of our business units for uniformity. So that principle of comity where one regulator sees, okay, this decision has come out, let's wait and see how it impacts how they do business in the rest of Africa, because surely they will want to comply with it, particularly where we have taken a wrong footing. So yes, it's quite a responsibility, but it's a responsibility we embrace because we understand it. All we're asking is for more uniformity in approaches and certainty in terms of why is there an issue and how can we, alleviate those concerns that regulators have.
Thanks, Homo. I think Makali may have a little bit too much of a bad rep as a regulator. We're going to have to give him a bit of time to defend himself. But in my experience with Makali, we've had a number of telephone conversations, and he's always had 3 very special words for me. They're not the 3 special words that I would like. They're the 3 words, come and settle. But Makali, so turning to you, and you've done significant work in the South African competition context, and more likely more broadly than we're even aware of. So the South African Competition Commission has probably been the most active regulator on the continent in relation to cartel conduct, and you were instrumental in establishing that division. I think it's a long question, so I'd say at a high level, what would you think that you would impart to newer regimes, or what should they consider when looking toward cartel enforcement?
Okay, thank you, Tamara, and good morning, ladies and gentlemen. Thank you, Bowman, for inviting me. It's really a pleasure to be here. So yeah, you are quite right. Please come and settle. Would you do that?
Talk over wine.
I'm encouraging you to do that. That's the best way you can resolve matters, is to come and settle. In that way, there are no problems. But there are only very few lawyers who know how to settle. You know, some lawyers, they litigate. And we always say, we are there. You know, we wake up in the morning, this is what we're going to do. It doesn't cost us that much as compared to the clients, because we cost the employer anyway, because the employer has to do that. So majority of cases that gets to be wrapped up quickly is because the other side is willing to take the offer to settle. And we're very reasonable. We have a very long list of cases. Some they don't want to go. Some they go faster, So yeah, settling, it's one of the way that we prefer actually to resolve cases. So when you have a case, come and talk to me. We can agree on the settlement. Yeah, so just to answer the question, yeah, you see, cartel enforcement, it's very tricky. It's for newer agencies, they must know that it's not like mergers where you get all the data prepared for you. You've got to search where you are not happy and ask questions. No, you start from scratch, nothing. Probably have a pager. You still have to build a case that you can put before the tribunal or court and defend it. So corporate leniency has been the most helpful tool in cartel enforcement. So with the leniency, at least you have one of the cartelists coming to tell you what they have done and giving you all the information they have, which will help your investigation. But even with the leniency, you still need to be very effective and efficient as an institution, because otherwise the leniency application will sit there and gather dust. It will not make an impact. The other thing is, even with the leniency to be effective, you've got to be very aggressive in enforcement. So in other words, companies and lawyers should know that you can uncover that cartel on your own. Because I'm sure lawyers sit and look, say, should I apply for leniency for my client? Maybe they won't catch them, it's fine. Let's wait and see. We'll come knocking the following day. You wonder, where did you go wrong? Because ideally, you should have come and applied for leniency and would have protected your clients. But for them to start thinking that whenever they get the information, they must approach the authority quickly. It's because of the effectiveness and perhaps some little bit of aggression in the enforcement. Then in that way, they know that we may be caught and we might be fund winding for our clients. So it's a combination of things. I mean, most of the cases that we have finalized, the big cases, talking construction cartel, we uncovered that through a leniency program. Talking about, let's say, the Forex cartel we are currently prosecuting. We have uncovered that through a leniency program. And these are cases that ideally without leniency, you would not get them, you know? And when I come knocking and say, hey, I have a case against your client, you must know that I have information. I'm not just saying I have a case in a fishing expectation. You're gonna ask me, do you have a leniency? No, that question we don't answer. Apply for leniency if you want to know. Then we'll respond to you. We'll tell you are second on the queue. Then you know that it means there's somebody else or you are first. But most of the time on these big cases, very big cartels that you've seen, there is someone who has come forward. I mean, Deringer used to do that. He used to, whenever we rate the client, the first thing he does is to file a marker. And then he searches with us. Let's see what we get here. Then we'll apply for leniency, which was a smart move because he protected the clients because he knows that when we come knocking, we are not just in a fishing expectation. We have something. You've set out the test for starting the investigation. You know, there must be a reasonable basis. You know, there must be evidence, prima facie evidence that there is a cartel. The test is even lower for a rate. You know, it just needs a reasonable suspicion that a cartel is taking place there. We go to court, get the judge to give us a warrant. We come. We rate you. So yeah, I mean, for newer agencies, I think, I mean, we have been doing this. At least we have been having cartels division for, say, the last 10 years. It has been existing for 10 years. It has done very well in the sense that the number of cases we have uncovered and processed, finalized, the stats are there, quite big cartels, some regional cartels that unfortunately we were the only ones prosecuting them. Not blaming you, COMESA, you were not there at the time, but I think now that you are there, whenever there is this cross-border cartels will obviously, as our regional body authority, will obviously tell you. We've worked with the Kenyans quite a lot. Myself, I think I've spent like a month in Kenya when they were studying their law. I've worked with almost everybody in the region. Unfortunately, it's still, some we're still building. And I think we just need to be patient and assist in the building. But ultimately, the key is that if you want to be effective in cartels, you have a leniency, be effective and be aggressive in the enforcement. Thank you.
Thank you, Makali. I'm a bit concerned that you're giving these other regulators ideas. I saw Siboni taking a few notes, and I'm trying to see if she was writing aggressive, but unfortunately I can't see that far. So maybe just to take a step back and look to Thomas from a global perspective, to ask, are we seeing, Thomas, any shift in focus, and what type of behavioral conduct do you think is most likely to be scrutinized this year and beyond?
Right. Yeah. So I think, Tamara, sort of at a global level, it feels like cartel enforcement might be back. And I say that because we've clearly gone through a period where cartel enforcement looked like it was a little bit less sort of the key focus of competition authorities. And for example, also in our practice, if you sort of see proportionally how much time you sort of spent on different types of work, certainly we also saw a decline in cartel enforcement, maybe an uptick more in sort of vertical cases and certainly abuse of dominance cases, big tech and what have you. But so if you ask yourself, why was cartel enforcement down, or why were there fewer big cartel cases? Certainly there were less of the global sort of cross-border cartel cases like we had over vitamins, car parts, etc. Those didn't seem to be around. And then you can ask yourself, is that just because finally all those compliance efforts paid off and there are just fewer cartels? Might well be the case. Or detection might be down. Certainly, antitrust authorities have seen globally fewer leniency applications. I know we'll come back to leniency and detection a bit later on, but certainly that has affected things. And then there were also fewer dawn raids, and certainly with the pandemic, for sure, that has had an impact in terms of sort of the cases that were being done. But we see an effort of antitrust authorities to sort of warn companies, like cartel enforcement is still there. The European Competition Commissioner Margrethe Vestager recently referred to cartels again as the supreme evil. I think she was forgetting about Vladimir Putin for a moment, but cartels come just behind. But also more concretely, we've seen actually, and in Freshfields, we've done sort of this, we do an annual review and sort of predicting trends. In the past year, we've seen in Europe about 40 dawn raids in 15 different countries. So clearly, post-pandemic, antitrust authorities have sort of again gone out and do the dawn raids. What we also see a lot is what I like to call virtual dawn raids. Essentially, antitrust authorities sending very, very detailed requests for information, essentially, please produce all your documents, as if they were sort of just coming to your offices, but without having to do that and under the threat of very serious penalties, asking you to produce the document. So certainly big efforts being made to show and speeches being given to show that cartel enforcement is still around. I think secondly, the trend that we are seeing a lot is maybe fewer of sort of the traditional horizontal price fixing cartels, but enforcement in relation, for example, to buyer cartels, so purchasing cartels. There was a case in ethylene we were involved in Europe. Likewise, technical developments. There was in car emissions a big case in Europe recently. It's now pending before the courts, where again that wasn't just about fixing prices. That was about sort of agreeing to the Commission claims limit innovation. You also see, for example, cartel cases on product characteristics. And then there's also a sort of information exchange, which is always sort of this gray area, obviously, as well. So that's I think how you see sort of the shift away from the traditional cases of being maybe found out in the more traditional ways to sort of a new area of cartel enforcement.
Thanks, Thomas. And I think I'd like to come back to you on leniency in the EC. Makali has already taken us through the significant impact of the leniency policy and its role in enforcement of cartels in South Africa. Then maybe to ask Joyce, I believe Kenya has used the leniency policy, and wanted to put it to you if you think it's been useful in the detection of cartel conduct, and if there's been any particular industries that the Competition Authority of Kenya has focused on, or that you feel should be areas that are focused on.
So that's right. Actually, in 2014, the Kenyan Competition Act was amended to give the authority power to put out a leniency program. And in 2017, they issued guidelines around what that framework would look like for the leniency program to operate. Has it been effective? In my view, no, because I'm not aware actually of it having been used. But also, I think the big concern is the way the guidelines work is, first of all, you put in your marker, and potentially you can get immunity from 100% of the penalties that may apply for your cartel behavior. But there's a requirement for you to cooperate fully and to assist the authority to actually successfully conclude its investigation. So it seems there's quite a high standard, because if the investigation is not concluded, and if they can show that you haven't cooperated fully, you may not get permanent immunity. And I think the guidelines then say that you could also the authority could revert back to an investigation process against you. So I think there's a bit of a risk there, that if you put in your marker and you don't succeed in, and the authority doesn't succeed in the investigation, you could have exposed yourself to something. And I think also it's not clear that you have immunity from criminal prosecution under the guidelines, because that is not in the mandate of the authority. It sits with the Director of Public Prosecution. And the guidelines say that, it is subject to concurrence of the DPP as to whether or not you get immunity on the criminal prosecution. So in my view, that's why perhaps it hasn't really worked. I think perhaps in Kenya, the more effective tool has been dawn raids, because in terms of industries or focus, I think I would certainly say the most the sector that has attracted the most scrutiny from the authority is the manufacturing sector broadly, where in 2018 it conducted a dawn raid in the paint manufacturing industry, and then just December 2021 in the steel sector. And both of those, I think, from the authority's perspective, were quite successful cartel investigations. The paint one was settled by a number of players. I think two of them chose to fight it, and I think they're still at they went to the tribunal, and then they're at the High Court. In the steel sector, it's still very much an ongoing case, and that was, from the authority's perspective, you could see the growth in the capacity and access to technology, because they did the raid and it was so efficient, and how quickly they were able to turn around the content that they got from the dawn raid into an actual notice of investigation. And the program, the investigation has actually moved very swiftly. So it does show you that in terms of the trend, I do think we're going to see more cartel enforcement. I think the authority has built capacity in terms of, headcount, people on the ground. They've invested in technology. And I do expect going forward, we're going to see a lot more. And, perhaps like has been mentioned, the more aggressive the authority gets, perhaps then the more likely it will be that the leniency program will come into use.
Very good point. Thanks, Joyce. Don't want you to give Macaulay too many ideas
know.
about greater investments into, but thank you. And just before turning to Siboni, Thomas, we spoke about Europe as well. Has the EC's leniency policy has obviously been important to its success in this area. Do you think there are parts of this policy that are most critical, and anything that you think that should be changed to increase the detection of cartels?
Right. Yeah, no, I think Tamara, it's right. From the authorities' perspective, and as I mentioned, they sort of recognized that there was sort of a bit of a lack of new cases. They've done the analysis. They've seen that leniency applications have been down. At the same time, the other way of course of enforcing is to go out and detect the cartels themselves. So on leniency, why was that going down? Well, I mean, you can sort of speculate about the effectiveness of compliance, etc. You can also wonder, are practices just even within companies less easily detectable? And I'll come back to that. But I think the main reason in Europe why leniency was down was the success of follow-on damages. So we introduced a number of years ago a European directive, and now member states have all the sort of the ability for victims of cartels to go and claim damages. And as advisors, as companies, when you sort of make the trade-off, do you go for leniency when you detect something or not? Do you just put your house in order? You no longer just have to look at sort of the potential fines that you are getting protection against if you go for leniency, but you also have to take into account the exposure to those follow-on damages. And really that's become again an area of practice that's really boomed tremendously, including with mass claims, etc. In several member states, and also in particular in the UK. So what to do about that from the European Commission's perspective? Well, first of all, there is talk about giving the immunity applicant also some protection against follow-on damages, but that's of course a difficult debate, because you sort of wonder, is it fair to protect somebody entirely from fines just because they go and declare not only fines but also damages just because they go and sort of blow the whistle. In the US, you have protection against treble damages, but we don't have treble damages in Europe. So that's a whole debate that's ongoing. More concretely, what the Commission has already done, the European Commission, is to put out some guidance, possibility for companies and their advisors to go in on an anonymous basis. And this is against the background of, as I mentioned, sort of new types of cartels being prosecuted. You can now go in and discuss through your outside advisors whether a certain type of conduct would qualify for leniency, because of course it can also be a hurdle to go in for leniency if you don't actually even know whether what you've been up to qualifies as a cartel. And the leniency rules in Europe are quite specific in terms of what they protect and don't protect. It has to be sort of hardcore cartels. And so when in doubt, you can now go in and clarify that. So that's on the leniency side in terms of maybe ways of stimulating the the flow of new cases coming. The other one on detection. So clearly, this is no longer about sort of smoke-filled rooms in a nice hotel in Acapulco, where parties sort of decide on their global cartel. Acapulco is now in cyberspace. Parties maybe have gotten more sophisticated about how they go about their cartel arrangements. So authorities have also felt that they needed to improve their own detection capabilities. And certainly at the European Commission, you see a lot of investment going into technology to detect, to monitor markets, to see whether trends are potentially indicative of cartels, and then also to go out and detect. So certainly that's also a trend that we are seeing, and it's also about authorities, of course, signaling like to individuals. You can't just assume that by sort of being more sophisticated about how you communicate to each other, that you won't be found out.
Thanks, Thomas. Sounds like there's lots to watch out for as we go more and more into a digital world. But turning back to Siboni. So Siboni, at this stage, I think COMESA doesn't have a leniency policy in place. And from what we've heard, especially from Akale and also from Thomas, this seems to be highly effective. Is COMESA in line to introduce a leniency policy? And is this something we should expect in future?
Yeah, thank you, Tamara. So what we did at the Commission is, under the current legal framework, we engaged our stakeholders on how we could design a regional leniency program. And our engagement with stakeholders at national level made us think quite a bit about how to balance some of the nuances at national level that could possibly affect, regional leniency applications, such as criminal sanctions in one member state and no criminal sanctions in the other member state. And how do we balance that? Because even if we take up a regional cartel at COMESA level, member states are 100% sovereign. They have a right to criminally prosecute anybody who's been found to have engaged in a regional cartel. And that put a bit of put a huge speed bump in putting out those leniency guidelines under the current legal framework. But what we've now done is we are amending the regulations, and internally the consultations on the regulations is at a final stage. So this year we will be rolling out the proposed amendments for stakeholder input, just to help us see how we can factor this in. And we will make provisions for the leniency program in the regulations themselves, because when we engage with our member states, there were also questions about, if the leniency is not provided for in the regulations, then can we really enforce? Can we really implement? And so that's what we've tried to do, is to introduce the leniency in our regulations, with the hope that Homolemo's dream, which is all our dream as enforcers, that the principle of comity, that if somebody, gets into trouble in one jurisdiction, they'll go to the other jurisdictions and say, guys, come, I'm in trouble. Because, also as investigators, right, we also want, principle of comity, because it also helps us to rationalize our resources, to say, let's do everything together. Let's not have a duplication of efforts sometimes. And so we do hope that once we have our new regulations passed, that we can start to see companies coming forward to say that I have been engaged in conduct, and I'd like to bring it to a stop. But what I think is also important to appreciate about the regional regulations is we deal with an additional element to our cases beyond competition, which is the trade between member states. And I think this one, our stakeholders, even today, perhaps our stakeholders might not be necessarily conversant with that. And this is how we tend to see as regulators that we have companies that geo-block their compliance. And this is not unique to COMESA, because even in Europe, we see cases being discussed in Europe. I mean, look at the privacy case against WhatsApp that was only implemented in Europe. And in Africa, I think Nigeria was the only country that went after them. So you're protecting your consumers, you're protecting your users in Europe, but you're taking our data in Africa. That doesn't make sense. And that's a classic example of geo-blocking. And if big tech can do it, then certainly it's happening on the common market. And so I think that's an important one that we really need to engage our stakeholders on the advocacy, to say that, in addition to you might look at, your conduct from a competition perspective and you self-assess, like Joyce said, you self-assess and you think you're okay, but you actually have to appreciate that at regional level, at COMESA level, there is this element of trade between member states. So even if you think you've fixed your conduct in one country, or if you believe that you've sanitized your businesses in a particular jurisdiction, it is possible that you're still violating the regional law, because you're restricting, trade between member states, you're restricting regional integration. And for us, that is an issue. And so sometimes even, under the current legal framework, when we seek to engage businesses and we say, we believe you have this particular conduct, let's look at it. We appreciate that, there will be an element of self-assessment on the competition side, but just also appreciate that we have an additional factor to look at. And I think this will be important for cartel conduct as well, especially when you're looking at, issues of an export cartel or, a cartel somewhere that's coming to us, where you say, oh, we're not in COMESA, or there are no competition issues there. So it will be a lot of work. We appreciate that there will be a lot of work, but we're hoping that by the end of this year, I think we will have the regulations passed, and we can then work on putting together guidelines to see how that will play out and how we will cooperate with the national competition authorities, because there are quite a lot of considerations to be had. When you receive a leniency applicant at regional level and you alert your member states to honor the leniency that you grant, there could be questions to say, but have they given you, that how much information can we share with the member states, right? When we have a regional leniency applicant, because it is a regional investigation, but we do cooperate and we do collaborate with the member states. So there's quite a bit of nuance to be had at regional level, but I think we're up to the task. And certainly when the regulations the proposed amendments are shared with stakeholders, we look forward to hearing what our counterparts will share based on their experiences.
Thanks, Saboni. We'll certainly look out for the regulations. They're well anticipated, and I'm sure a lot of work has gone into them too.
Yeah.
Thank you. Having heard what has been said, I just want to turn to Homolemo. Homo, with increased scrutiny of possible cartel conduct, how would you say businesses should try to best mitigate their risks?
Thanks, Tim. Yeah, I mean, I think the trend we've seen in South Africa and internationally is more and more companies, particularly multi-jurisdictional operating companies, are building internal capacity, ergo hiring smart people like you, or poaching from the commission or academia or economists to ensure that in terms of just their day-to-day operations, they are on top of competition regulation. They know what's happening in their businesses, where the weak areas are, which parts require improvement, where the strengths are, where to cross-pollinate. So that's the first thing. You inevitably need a competition team that has got long-term expertise in this area, good relations with various stakeholders, including how well I get along with Mahale. The other important thing, I think it goes without saying now, that competition law is a focus area of any compliance program within a company. If it isn't, it should start being. The point I'm simply going to make is you need to sharpen that compliance tool on an ongoing basis and reinforce sharpening it on an ongoing and deliberate basis, because approaches change quickly. As you say, Kenya exclusivity and vertical agreements are still a thing. We see that across a lot of jurisdictions in Africa, to the level where I think the safe harbors that have been developed in the likes of the EU and other more mature markets has not quite caught up. The newer and younger regulators will always take a more conservative view, and the more mature and older regulators that have time to test drive their legislation and their regime will be a little bit more robust. And it's very important to see what in your company falls within what I'd call, the safe harbor, not safe harbor by EU standard, but in terms of what will generally be okay, even for, a new regulator. What is EMBA, in the sense that there's a high bar in major jurisdictions, but in the newer ones, you probably are going to agitate them. If, let's say, duration of exclusivity is beyond 4 years, that's kind of EMBA. And then the red zone is where no one is going to allow you to do an evergreen XYZ exclusivity. So you build that into your everyday business operations. I think I cannot underscore the significance of competition compliance has to be part and quite a vibrant part of the pulse of an entity, from conceptualization of ventures to agreements being drafted, to implementation, to continuous monitoring. Because you cannot, as a multi-jurisdictional entity, afford to be caught and be reactionary when you hear our regulators wanting to settle left, right, and center. It's a reputational thing. It costs a lot pecuniarily. And so it's essential to be proactive and to know what is going on in your business. One of the other tools that can be quite useful, but quite costly, and I think you'd have to have a good reason for why you would want to do this, are audits, where it's a pure competition audit, like governments do, where when they get a clean bill of health, they headline it, and it's all. You need to know what's going on in your operation, particularly the bigger an organization you're running. And if you see a weak area in one aspect, it might mean that there are many other weak areas. And what an audit does very comfortably, but as an expensive exercise, is it enables you to catch up with what's going on with your business. Is it in line with competition laws? Do the key decision makers know what decisions are problematic, what decisions aren't? Do they know who you are as an in-house competition lawyers? Do they know when to come and vet things? Or do they leave it to the end when things are already drafted and now you're a bottleneck and you are under pressure, one, from time, and you don't have time to properly consider the issues that arise, but also from, we really need this deal, don't mess it up for us. So that internal vetting process is quite critical on an ongoing basis. And a company that's got a great team that's on top of it, that takes our regulators seriously, will always be proactive and be mindful of, before they make announcements, before they implement collaborations, whether with suppliers, customers, or competitors, they've actually thought through the competition implications. And perhaps just for the benefit of the regulators, while I have their ear, something that certainly doesn't translate to us, but maybe it does happen internally, is what I've experienced in practice, and all I've done is competition law. That just makes me quite boring. But regulators have a huge repository of knowledge of different markets because they've been investigating them for a number of years. They know the markets. But what we're not necessarily clear of is, and we understand that there could be a resourcing reason for this. It is as if they're not building sector experts. So teams that focus just on broadcasting, teams that focus on oil and mining, teams that focus, so that institutional knowledge is a benefit each time there's a new investigation. They don't have to start with that long, detailed virtual dawn raid. There's a baseline. And we would be quite comfortable, I think, as practitioners. And I had a client, I won't say in which, I'll say the industry, but not the name of the client, in banking, where they said, look, every time there's an investigation at the commission, we're a highly regulated market as is industry, but our organization and products and services we offer are highly technical and complex. We're finding that we're having to start from the beginning each time to educate each new team about what we do, why we do it, before we can even get to what are the issues and is there a way of resolving those issues. So for me, one of the things that I think would help is if the investigators themselves cross-sell within the organization. If the same team can't investigate the same sector all the time, at the very least, when there's a new investigation in a sector where the commission has looked at it, they talk internally. What information do we have? They can even ask. I mean, I don't think we would have an issue. May we, yes, have a look. And then that info request that we get, we're happy to get an answer, is now about updating the information, what aspects of the market may have changed to either make issues that were not issues before now problematic, or the reverse to be true. And I think it would just be a much more efficient investigation process, at least in terms of how we experience and interact with the regulators. And I suspect it might even shorten the period over which investigations run if you're starting from a minimum base, and then it's just about, updating, cleaning up, getting, up to touch with what's going on. I think that for us, because of the level of scrutiny we have, it would really be helpful to have that internal advocacy, knowledge sharing happen within the regulators before they issued that virtual, or they institute that virtual dawn raid. Mahal.
Thank you, Khomo. I think Khomo has just given a homework assignment to Saboni and to Makale. But before, I think we're about running out of time. I just wanted to put a last question, if I may, to Thomas, in relation to following on from what Khomo has said about trying to mitigate risk for business. When looking at investments, how can investors shield themselves from cartel liability? And this question is put to you when considering, for example, the penalty that was imposed on Goldman Sachs in relation to its investment in Prysmian.
Right. So what can you, well, indeed, I think the starting point is, as an investor, you can indeed be found liable. In Europe, actually, if you own all or nearly all of the shares in a company, or you exercise all the voting rights, then there's a presumption, and it's basically impossible to overturn that presumption. But you can also be found liable if you control, so at lower levels of shareholding, if you're found to control the company. There's an added complication that the notion is not entirely the same as control in merger control. But certainly Goldman Sachs, for example, I mean, they owned Prysmian for 4 years. They actually pretty soon, they were 100% owner for, I think, only about a year, started selling down the shares. One of the 4 years they were even below 50%. They never knew that this was going on, yet they were held liable. And that's, of course, also because authorities will sort of go and try to find the money where it is. But I think all of this is also very relevant when you see antitrust authorities, for example, in the US, but also in Europe, signaling a sort of heightened scrutiny on private equity investors, for example, as well. So what can you do about it? Upfront, of course, you can do proper due diligence, and we see sometimes that due diligence really going pretty far, like almost like cartel audits, which, of course, if you're doing it before you even own the company, presents all sorts of interesting questions. But we certainly have had cases where that's been the case. You can also try to protect yourself at a contractual level in terms of how you split liabilities, indemnities. But in some cases, indemnities for this type of conduct actually aren't enforceable in certain countries. So you might want to think about adjustments to the purchasing price as an alternative there to make up for any cartel fines down the line, and those damages that I was talking about as well. It's also about concretely how do you cooperate if an investigation should be started, and the sort of the previous owners have sort of departed in the sunset. How do you sort of go back to the old evidence when you need to defend a case many years later? Once you are the owner, I think the lesson is really one of for investors. You cannot just sort of hide behind the fact that you're not running the day-to-day business. In a way, it is expected of you that you instill a compliance culture on your portfolio companies, and that's what we see a lot of these days as well. The investors really proactively working with their portfolio companies on having a culture of compliance, of conducting the relevant audits regularly, because the impact, if there is an investigation and if there are fines being imposed, can be pretty far-reaching.
Thanks very much, Thomas. That's great to think about. I think we are out of time, so I just want to pause here and see if there are any questions from the audience, and to also ask people to not run away, because my partner Marianne and Gumuthu is going to be delivering some closing remarks. So please stay with us. But if there are any questions, Dr. Mwemba.
Thank you. So my question goes to Mahale and Thomas. Two issues. The first one is, to what extent would you use economic evidence and market trends to prove the existence of a cartel successfully? That's number one. Number two, to what extent are dawn raids efficient anymore? Because I'm trying to think, do we have companies that are still that very stupid that they would put things in writing or evidence in their offices when they know, Mahala's told us that is very aggressive, when they know that he may actually come here? Are they still that, would they be that foolish that they would keep those things and wait for him to come? And then lastly, I think, Joyce mentioned that in Kenya, maybe the issue of lenience program has not been very successful. I see that in a number of jurisdictions. And we've seen a decline in the number of lenient applicants, not just in Kenya or South Africa or Zambia, but I think globally. For an agency like us who are thinking of coming up with a leniency program, is there an incentive rate to spend much more time in drafting that document when we are seeing that it is becoming largely ineffective? And then if that is the case, what other tools would be there? And obviously, Makhala, I'll come for tutorials. Please, I'll knock on your door. Thank you.
Okay, thank you. Economic evidence, very important, especially now in the era that we find ourselves as South African competent authority, wherein courts have said you must characterize a cartel conduct. You know, the issue of characterization most of the time requires us to have economists as part of our team. In the past, we never really used economists because our view was, and is always is, that cartel is a cartel. You know, this issue of characterization, it's actually very much foreign. And we are, of course, fighting it head on. But at the same time, we are making sure that we don't make a mess of our cases. We get economists to work with us so that we cover all the bases. But the issue itself of characterization, it's an issue that we would like to fight until we win it, because it's an existential issue for us. So and we're not gonna stop fighting it. That I can pretty much tell you. We'll do, if we can get it right, we will have to change the law and say that no characterization. Because the problem with it is that it's an amoeba, and you can't have a law that looks like an amoeba. It changes. Today it's characterizing this, tomorrow characterizing that. And I think it's just designed to exonerate firms that are accused of colluding. But we'll turn the corner. It's always a battle. We'll turn the corner. So, but also in some cases, you do need economic evidence to make a determination as to whether there is a cartel in a sector. You need economists to do some researches for you to put these things together and say, well, the structure of the market, suggests that, there may be coordination. Usually, some of these things then emanates from mergers. You look at the merger, they do analysis, and then they say, hey, there may be a problem here. I do have a team of sniffers, those that their work is to look for cases, go out and look for cartels and gather information, build a case until it makes sense for us to initiate investigation. So usually then they will then have to work with mergers in that scenario. Of course, when you do measures, we have economists there that are helping. Don rates, I actually like Europe. They said they had 40. I want to have 40. UK, they say they rate for each and every case, they do a rate. So, and I would like to do that. I would like to do that because, you see, you are quite right. When we do don rate, we are not necessarily looking at the hard copies anymore. We want electronic data because you're quite right. You can't find, of course, you can still find someone leaving these things lying on the table. We did one don rate and an employee asked us, what do you want? He was irritated. And then we said, we want a cover code. He says, yeah, they're here, come. And they gave us the things we're looking, he gave us the evidence, thinking that we will go and she was just irritated by our presence. So, don rates are the most effective way of gathering evidence and of fighting cartels. Without don rates, even leniency is not effective. So the effectiveness of leniency depends on your enforcement strategy. So if you don't rate, you're not gonna get leniency. They say you are sleeping. So they say, no, he's sleeping, let the sleeping dog sleep. But when you do don rate, that's why I want to do don rates for each and every case. And I am working on that. I can give you heads up that I am developing internal capacity because it's expensive to rate. The machineries that I use, the software, the tools, what, I'm developing that internally so that I don't need to spend to rate. So I can rate for each and every case. I take my team, let's go. We carry our machines. We get there, we plug, we go. Tomorrow we are there. So you'll be busy chasing us. I'm giving you a hint. So when it happens, don't be surprised. Yeah, so it's very effective. Is the most effective way actually of gathering evidence. It's the most effective way of ensuring that you become effective as an enforcer. because they know that, and it will give you leniencies. If they know you can arrive anytime, leniency will come. And when you do that, settlements come. You will settle cases, you resolve matters. But if you are just sitting hoping that some miracles will happen, they will never come to you, these people. They will never. They will, he's sleeping. Let them sleep. Thank you.
Thank you, my colleagues. Some serious heads up there. We take notes. I see another.
And by the way, that's the point I wanted to talk about.
Okay.
The question was spot on.
Duly noted, sir. Thank you.
Afternoon. This is a question for Ms. Maseko. Just asking about the transition for COMESA, and I guess for Dr. Mwemba as well, the transition for COMESA into going into behavioral practices. So is that something that happens just as a consequence of having more staff and more resources? Or how does like a young, if you want to call it that, competition regulator transition from focusing on mergers into then looking into anti-competitive practices? So what do you think has changed in the last few years in COMESA?
Okay. Do you want to take a stab at it, or should I start? Sorry. I think the first one that starts is, first of all, your stakeholders understand your interpretation of the law, and they get an appreciation of your reputation as an enforcer. So when a young agency comes up and the focus is on mergers, everybody wants to see how strongly or how aggressively you're going to enforce. And when you build that expectation to your stakeholders that I am going to investigate and I am going to assess mergers and enforce the law, then they are more willing to come forward. And to engage you on some of their conducts. And taking to Dr. Mwemba's session this morning about procedural fairness, everybody uses mergers as a testing ground to see what kind of regulator you are. Are you fair? Are you transparent? Are you approachable? Is your door open? Can companies come and speak with you? And once, because in a merger system, everybody wants to comply. It's very for the most part, it's very amicable. And so it's like testing ground. They say, Dr. Mwemba and his team, are they approachable? Can we reach them? Okay, so let's try with like a more problematic conduct. And the other one would be when you set your decisional practice, and again, I will refer to the appeals decision that talks about, commitments, how we approach commitments, right? To say that when the investigators and the respondents in a matter come to a common understanding on undertakings or commitments, how should our decision makers approach that? How should they handle that? And so it's over time, it comes with learning on both sides as enforcers and as the market. So the first one is that the market appreciates that we're coming to do our job. Maybe not as aggressively as Mahale. We will take the virtual dawn raid, like Thomas says. We'll send a virtual one and say, give me everything you have for the last 10 years or whatever. And they do give us. And so that's our virtual dawn raid, right? So it's a learning that, your stakeholders need to understand that you are enforcing your law, and that, this is procedurally, are you fair? Are you transparent? And then decisionally, where are we going? And then I think with that, then also internally, now as enforcer comes the appreciation that actually if my market is taking me seriously, then I can invest resources into my staffing, into my infrastructure, because then you can motivate to your principals to say, when we started, you actually weren't sure that you wanted to invest, right? But invest in staff, invest in infrastructure. But now you can see the number of cases that we're dealing with. You can see the complexity of cases and how technology is affecting everything. And so it's on both ends, it's all these relationships with a multitude of stakeholders, and then you build yourself up to that.
Just to add what Wanda said, in our case, I think there's another very significant consideration in that we are dealing with different countries, with different competition authorities, and there was a question in the morning that all competition authorities respecting the one-stop shop. So you can imagine if we are having those questions still on measures, then those questions become serious on things like cartel and other anti-competitive cases. So it had to take time to build that trust with our national and member states and national competition authorities that actually this can be done at regional level. And like Sibona said, I think the trust was built from the way we've been handling measures and other horizontal cases of less significance compared to cartels. When that trust was built, it has now become easy for us to get such cases, and Kenya will say, yes, we are fine. Zambia will say, yes, we are fine. And that's why Sibon was saying some of the cases that we're dealing with now, cartel cases, we have countries like Kenya, Seychelles, Mauritius, very much supporting that process because we think that's our view, that they've now built that trust that a central body can actually do that on our behalf.
Yeah.
Thank you. And of course, resources. But look, when we started at Derek, you'll recall that I was the head of measures, I was the analyst, I was the receptionist in measures, I was everything. Okay. There's no way you could have then said, let's do more complicated cases like cartels with that less workforce. We are now 35 from what we were 10 years ago. That's a good number now to say we can get into other areas. Thank you.
Yeah. Unless we have anything else, I would like to thank the panelists for their fantastic contributions, from the aggressive to the thought-provoking, and to ask Marianne and Gumuthu to please deliver some closing remarks for us. Thank you.
Good afternoon, everyone. I won't keep you very long. Thank you very much for making the time to come to Cape Town to share the conference with us. Thank you also to all the panel members for the very insightful and entertaining discussions. And we really appreciate all the effort that they've put into making this conference and a valuable exercise for all of us. And what I want to start off by saying, and which Magale has made very clear to all of us, is that we can't underestimate how important competition law is. We are compelled to take it into account when we make merger notifications, but we are also compelled to take it into account in how firms conduct themselves in the market. And if you were in any doubt before, Magale has clearly told us he's got a team of sniffer dogs and he's going to come and find you. So competition compliance should be, as Khumulemo also warned you, at the top of your list when you're considering which regulator to prioritize. On a different note, and a more serious note, we heard Dr. Ngube tell us earlier this morning that he sees the role of the competition authorities, or one of their roles, as making South Africa a better place, and that the public interest provisions is one of the tools that they want to use to make South Africa a better place. But in considering what is a very important statement by Dr. Ngube, we should also think about the following, that in 2023, South Africa was rated as having the highest unemployment rate in Africa. More than 30% of our workforce is unemployed. And one of the reasons for that is that we can't match the creation of jobs with our growing population and with our growing workforce. So our appeal to our competition authorities when they apply public interest provisions is to bear that in mind. We fully appreciate the policy objectives behind the public interest provisions. We understand the change that needs to happen in South Africa, and it's a change that other African regulators are also seeking to impose. But in considering those provisions, we should bear in mind unemployment rates that need to be taken into account, economies that are still developing. And we urge you to take investment into account and to count investment as an important factor when you're considering whether or not to impose conditions on a transaction or whether or not to prohibit a transaction. And on that note, I want to speak to Dr. Mwemba, who's one of our favorite regulators, as you can tell. Thank you for encouraging us and telling us that you see investment as an important objective and that you've yet to prohibit a transaction because you see investment as important. I would ask you to please talk to your comrades and the other regulators and give that very sound and reasonable advice. And you're always so appealing to us, so I'm sure you'll appeal to them. And finally, Mr. Mohale, please stop giving advice to Dr. Mwemba. I've been in a dawn raid with Mohale and we spent a late night in downtown Johannesburg. So I know firsthand what he's talking about with his team. But thank you everyone for coming, and there's lunch outside. So please don't go away without eating something. Thank you.